Cross objection 15 of 18.
Appeal is partly allowed with regard to the quantum of interest only. And the cross objection stands dismissed.
Oh, this is 1192 the appeal as well.
RFA 119 of 2017. Cross objection 13 of 18.
In the judgment just pronounced, we have practically we have dismissed the appeal, but that quantum of interest from 12 to 10. The appeal stands dismissed and the cross objection is allowed with a direction for remand to the learned trial court to decide the issue of damages compensation.
Keep your way.
Litigation 954 of 2026.
Dismissed.
Obliged.
Yes, mention.
Hey, please, your Lordship. Lordship, I beg to mention item number 26, Lordship. Lordship, case diary is not available. Lordship, a date may be fixed, Lordship.
She did not available. List again on. Ashit.
Lordship, TCR may be called for in the.
All right. Ashit submitted. Right. CS number.
Height CS number Malak C1/2026 dated 31/3/26.
Date did.
14.
PCR call money.
14B.
Please can copy of this.
Malas, item number 40, Malas, some accommodation, and can it be upgraded? The part had matter, Malas.
Let's get through the bail hearings first.
May I please, Lord? Lord, I beg to mention item number 24, my lord, on today's list, my lord. Item number 24. This will
Yes.
actually come up after 2 weeks, my lord.
CD also not
24.
C did not receive. List again on.
PCR call for PCR not received.
PCR not received. List again on.
25B.
Obliged.
Issue reminder will be.
One more pair, my lord. I'm praying for listing of a bail application, my lord. Next week, any date, my lord.
To go to senior bench.
Obliged.
May I please also, well, item 46, my lord. I am appearing for the petitioner. I have informed the other side also, may be taken up after 2 weeks, my lord. Item 46, my lord.
All right. For 2 weeks, they did the petitioner and consent of the respondent. Yes.
May I please?
Yes.
Up to 2 weeks.
22. I
May I please also. I am praying for short accommodation in item number 37, lordship. CD has been received, lordship. Could it be taken up on lordship 7th of May, lordship? CD may be retained till then.
Why so long?
7th, lordship, next week.
Next week, not 7. Next week.
How it is taken?
Yes.
7th.
7. All right. CDB retained till then.
Obliged.
May I please, I beg to mention item number 23 on TCS. Yes, was called for TCS of TCR was called for it. I think it is not received.
33.
No, 23.
23. PCR not received. Issue reminder. List again on. Yes.
May it please to your lordship, I beg to mention for item number 43, senior counsel has some difficulty today, kindly matter may adjourn.
You know,
With the consent of other side, we have taken consent.
All right. List again on. Give it date.
Lordship, if possible, 28/5
28/5.
oblige.
It please, your lordship. In item number 53, lordship, we have filed an additional affidavit. I may be allowed to bring that on record. Oblige.
May it please your lordship. Lordship,
Yes.
I beg to mention item number 33. Lordship, due to some personal difficulty, my learned senior counsel won't be able to approve for this matter today. So kindly matter may taken up on 6th of May.
All right, 6th of May.
Much obliged.
May I please your lordship? Lordship, with the consent of the other side, I beg to mention item number 42, lordship. Kindly adjourn the matter for a day, lordship, because my senior is out of station, lordship.
Oh, my lord, I am for the other side, my lord. Can it be on 5th of May, my lord?
All right. 5th of May.
Oblige, your lordship.
May it please, my lord, in
Yes.
item number 17, kindly pass over this matter for today.
17.
17. 17. Interim may continue.
List next week or did you?
also not received, my lord.
CD not received. Okay, list again on
11 May.
interim order passed earlier to continue. Next date. Yes.
13. Fifty. At 50. Withdrawal at 50.
Lordship, I'm appealing for item number 50. Lordship, we have instruction from the petitioner to withdraw this petition.
You are?
I'm representing the petitioner.
Your name?
Udyan Bhattacharya, U Bhattacharya.
Huh?
U Bhattacharya, Udyan Bhattacharya.
Your name is not.
None of the listed councils are available.
I'm appealing on behalf of my senior Dara Kulla.
Mr. U Bhattacharya, learned counsel appearing for Mr. Darakulla, learned counsel. Seeks leave to withdraw the instant petition. Prayer is allowed. Dismissed on withdrawal.
If you want.
Also, please.
May your lordship, I am appearing on behalf of Engaged Counsel R. Borua,
Your name?
M. Sutradhar.
M. Sutrodhar. Appearing for Mr. R. Borua. Please, for same order.
Open the item number 1.
Next, yes, lordship,
NDPS.
regular bill petition, lordship.
Commercial?
No, sir. Only 11 grams of suspected heroin. Lordship, he was arrested on 29/3. Now 33 days in custody, lordship. And recovery from his possession only 11 grams of heroin, lordship.
All right, CD.
On my 14th.
Yes.
Item number 2.
Lordship, short page, Haju, it is from Haju, lordship.
Yes, my lord.
May I lordship? But the petitioner is behind the bars for last 20 days, my lord. And the main, he is not the name accused, my lord. And the name accused already granted NDPS bail, my lord. This is the order, my lord. Can you have it, my lord? The main accused, my lord, some Papu Bora, my lord. And he was granted NDPS bail. The FIR is, my lord, page 13, there's a Bhane Kula.
If main accused has been granted
Anticipated bail.
anticipatory bail, then why have you not applied for bail there?
And we have put this, my lord, CGM, my lord, CGM rejected, my lord.
Where? Here, there.
My lord, Dhamaji, my lord. I have next, my lord, page 18.
Attack the
Several persons, my lord, name accused, my lord, this is Papu Bora, my lord.
Main
Led by
accused
20,
Papu.
more than 20 people, my lord.
They attack the polling officers and all this.
Papu also got it.
Papu Bora, he is the
He's the main accused, my lord.
main grounds in page 16, para 5.
There is allegation of grievous injuries. We don't know. Papu Bora may not have caused it. You may have caused it. Who knows? All right, CD. So,
13th.
13.
Diploma.
Item number 3.
Please, your lordship. Lordship will find the FIR at page 11.
11. Yeah.
Page 11, lordship. May I read, lordship? Respectfully,
You
FIR
are Moni Borua. What? Who?
yes, lordship.
Yes.
Respectfully submitted that on dated 2/1/2026 during my absence from home, the accused, namely Moni Borua, eloped my daughter, 17 years old daughter, namely Srimati Simpi Bora. Subsequently, the family members of the accused arranged a marriage between them without knowledge of or consent of me. After a few days of marriage, while the accused Moni Borua was absent, the second accused, namely Sri Thangaram Borua, father of Moni Borua, started making lewd gesture towards the victim. He physically touched her, kissed her on the cheek, and improperly touched the private parts. He continued to harass and torture her in this manner repeatedly. Being in helpless condition, she informed both her mother-in-law and her husband, Moni Borua, about the incident. However, they ignored her complaint and did not give any importance to the matter. Finding no other alternative, she contacted me over telephone and narrated the entire incident. After that, I brought her to the police station. Lordship, now the forwarding report at page 16, para 4, the police has collected the birth certificate, and after that, her age was detected as 17 years, 9 months. And she herself eloped with the petition number 1, lordship, and got married. They were in love affairs, and she persistently repeatedly requested him to marry her, but if he denied that after 3 months he can marry. But she was adamant, lordship. She told that if you don't marry, I may commit suicide. Therefore, finding no other alternative, he married, lordship. Moni Borua, petition number 1.
Without informing the guardians, my lord.
It is there.
In such situation, guardians may be informed, my lord.
It is there. Now, she was at that time of occurrence, she was 17 years, 9 months, lordship. And now they are in custody for 68 days, 1 day, minus 1 day, 60, it will be 69 days. There is a case, and all, I have
the
stated,
forwarding report, although marriage is there, there is no allegation of sexual intercourse.
yes. And lordship,
By the husband at least.
in paragraph 7, I have stated that charge sheet has already been filed and present case is in evidence stage. Therefore, lordship may.
On the charge sheet.
Yes, charge sheet and evidence, the case is in evidence stage, lordship. And there is no sexual harassment, lordship. In
Hard learned counsel for the petitioner and learned additional PP. This is an application under strength of the allegation against the present petitioner.
petitioner's, lordship, too.
Both father.
Both are there.
Yes, father also.
Application as stated in the FIR is that the accused. Where is the husband? Moni.
Moni Borua is the husband, lordship.
Accused Moni Borua had kidnapped the minor daughter of the informant aged about 17 years, 9 months. And the second accused person, who is the father of the first accused, solemnized the marriage of the victim and the first accused, and thereafter the second accused person inappropriately touched the body of the victim and kissed her. Full stop. The investigation of the case is over, culminating in a charge sheet, and the petitioners have spent 68 days in custody. Having regard to the above, the prayer for bail is allowed. 50,000, 2 securities each. It is further provided that the petitioners shall not try to contact the victim or influence the witnesses in any manner. Petition stands.
Deeply obliged.
এটা line সোমাই দিব, a perusal of the forwarding report does not indicate that after such after the elopement or solemnization of marriage, any of the accused persons had sexual intercourse with the alleged victim. Yes.
Bail application, Lordship, FOXO is involved, so at this stage I am only asking for notice and TCR may be called.
TCR.
Scan copy of TCR, notice to respond number 2.
Published.
It will be. Item number 5.
May please, your lordship, for a TT application, lordship.
Yes, what's the matter?
For page number, lordship.
But you can't find the FIR.
Sorry, lordship. Page number 18, lordship.
Is that page number 11?
18, lordship. 17.
Your name is Puna Gogoi
Puna Gogoi, lordship.
and
And Narayan Gogoi, lordship. Narayan Sutia and Puna Gogoi, lordship.
what is at page 11?
Page 11,
Type copy.
type copy, lordship. May I read, lordship?
This is cross FIR.
Cross FIR, lordship. Cross FIR, page number.
Theft of cow.
This is the relevant affair as page 11, my lord, because page 12, the syllabus of PS case number 57 of 26, they have select. And page 17, he saw, my lord, it is, that is the cross affair subsequent.
Basically, theft of cows.
Lordship, actual fact is, lordship, page number 26, lordship. Kindly go to the, this is the FIR, lordship. Main facts of this FIR, lordship. Informant Bobita.
When were you arrested?
Arrested on 19/4/2026, lordship.
Age?
Page 26, lordship. Informant Bobita Suta, lordship, lodged the FIR. May I read, lordship?
Yes.
সন্মানপূৰ্বক বিনি নিবেদন এই যে ওপৰত উল্লেখ কৰা পদকীয়া সকলে 16/4/2026 তাৰিখে বৃহস্পতিবাৰে বিয়লি প্ৰায় 3 বজাত মদ খাই আহি মোৰ বৰ্জনা শ্ৰী ৰাজীৱ চুতীয়া পিতা শ্ৰীযুত লোহেশ্বৰ চুতীয়া কোনো কাৰণ নোহোৱাকৈ গাঁৱৰে নিবাসী শ্ৰীযুত বিচিত্ৰা চুতীয়া ঘৰৰ পৰা মাৰপিট কৰি ধৰি নি আনি ৰাস্তাত বান্ধি গোটেই কেইজনে চৰ গুৰ ঘোষা মৰাৰ লগতে ডিঙিত টিপা মাৰি হত্যা কৰিবলৈ লওঁতে মই দেখা পাওঁ এৰুৱাবলৈ দিবলৈ লওঁতে মোক মাৰিবলৈ খেদি যায় আৰু মই কোনো মতে পলাই প্ৰাণ ৰক্ষা কৰোঁ উল্লেখ থাকে যে তেখেত সকলো আমাৰ দুয়োজনৰে যাতে প্ৰায় যতে পাওঁ ততে মাৰিম বুলি হত্যাৰ ভাবুকি দিয়ে লচিত upon receipt of the said এজাহাৰ লচিত Silapatha police registered case as the Silapatha PS case number 58/2026 lordship under section lordship one on 15 clause 2 127 clause 2 315 clause 2 and 3 clause 5 lordship BNS lordship. That's why lordship informant Rajiv Guhai lost the FIR lordship.
But that FIR is registered earlier, 57.
57
This
lordship.
is subsequent what he said.
Same day incident lordship. Their offense lordship follow. Rajiv Sutia not stated lordship.
No, but in the second affair, complainant is one Bobita Chutia.
Bobby Sutia lordship.
Where do you come into the picture here?
Mr. Lordship, Bobita Sutia is the daughter-in-law Lordship, Rajiv Sutia Lordship. FIR page number Lordship 17 Lordship.
Okay, Rajiv Sutia. Who is Rajiv Sutia?
Rajiv Sutia Lordship, Lordship kindly go to the page number 17 Lordship.
Petitioners are Puna Gogoi and Narayan Chutia.
9 Sutia Lordship.
How are they connected to this affair? Show us that.
Rajiv Sutia Lordship kindly go to the page number 17 Lordship. Page number 17 Lordship. Another FIR Lordship.
This is another affair.
Another FIR Lordship. Mary Lordship.
Yes.
সন্মানপূৰ্বক মিনি নিবেদন এই যে যোৱা ইংৰাজী 18/3/2026 তাৰিখে মোৰ এহাল হালুৱা গৰু গুহালিত পৰা চুৰি হয় কিন্তু যোৱা 16/4/2026 তাৰিখে ৰাজীৱ চুটিয়া পিতা লোহেশ্বৰ চুটিয়া গাঁও হাটুলাচুক থানা চিলাপথাৰ জিলা ধেমাজি দুজন মানুহৰ সহযোগত হাটুলাচুকৰ নিবাসী শ্ৰী মেমেৰা চুটিয়া ঘৰত গৈ গুহালিৰ পৰা গৰু পঘা কাটিছো বুলি স্বীকাৰ কৰে আৰু লগতে 1 নং পদকীয়া শ্ৰী নাৰায়ণ চুটিয়া 2 নং পদকীয়া পুনা গগৈ এহালি হালুৱা গৰু বিক্ৰী কৰিছো বুলি নিজ মুখে মন্তব্য কৰে হেহে গৰুহাল মোৰ সন্দেহ হৈছে বুলি this is a suspected FIR lordship they commit another FIR lordship এজাহাকাৰী ববিতা চুটিয়া lordship his this FIR lordship Rajiv Sutia accused lordship Jugen Gogoi one Bimol Sutia lordship Khirut Sutia Bhaikon Guhai Sinu Guhai lordship Lepai Sutia all that commit the offense that's why they lost the FIR another FIR lordship with the false allegation lordship.
Page 28 is the grounds. Forwarding report. Perato accused person running cattle business since 20 years. Previously, he was involved in cattle thief in Silapatha PS
But
area.
they are not mentioned the case number lordship on the counts of arrest lordship. Point number 2, 3 lordship. Totally false FIR lordship. They mentioned in their FIR lordship এজাহাৰ সন্দেহৰ ভিত্তিত এজাহাৰ লordship. But police Rajiv Sutia not arrested by lordship.
Still very early.
Kindly allow the lordship.
I'll produce the city by 12.
The allegation against the totally false lordship.
You are not that innocent, it seems, from the multiple affairs. That we should grant you bail on the first day itself.
As on the
Let's have it
petition
a little before that. Let's have it on 7th.
7.
All right. 7th. CD.
File up.
item number 6.
May I please the lordship, lordship, pre-arrest, lordship. Lordship, FIR page 12, lordship.
Yes.
May I read, lordship?
Your
Lordship,
petitioner's name
cheating
is?
and criminal breach of trust,
You are
lordship.
Khanindra Nath.
Yes, lordship. Cheating and breach of trust, lordship. And original fact is that, lordship, real fact of the case of the informant as well as one Rupam Shrinkia are known to the petitioner and the informant. Original fact is that, lordship. Diganto, informant was earlier case, lordship. Informant and our petitioner, lordship. Another case earlier was filed, lordship. They got bail, lordship.
Stolen vehicles.
Yes, lordship. Earlier one case was filed, lordship. They got bail, lordship. And let's see.
All right, CD.
Lordship, protection maybe.
No, what protection? Vehicle theft.
Romia Malaton 12.
Yes.
Item number 7.
Obviously.
At this stage, my lord, PCR may be called for, my lord.
Mhm.
NDPS case, my lord.
Scan copy of TC.
And only one line, my lord, from the court of my lord, additional session judge number 5, my lord. Kamrup Metro. I'm obliged.
Lordship is fixing a date.
It's 15.5.
15-5.
15.5.
Item number 8.
Pre-arrest application, your lordship, NDPS is there. FIR is on page 13. But your lordship will appreciate the facts of this case. In this case, the main accused, who is who has been arrested, Moonbase 1000, he was arrested with 3 vials of heroin weighing 3.17 grams, your lordship, that is small quantity. Thereafter, the police went through all his belongings and everything. In that, there is one transaction that they found with me. I have annexed the transaction also, your lordship. It's in the last annexure. Based on that transaction, they came to my house, they searched my house. And as a result of the search of the house, they were able to find around 32,300 rupees, your lordship. Based on that alone, I have been implicated in this case, your lordship. Further, the main accused who was arrested with the contraband has also been released on bail, your lordship. And it is only small quantity, your lordship. Your lordship will find the bail order at page 22.
That may be a small quantity from that person, Malad, but if he is Malad, giving money, helping him, Malad.
Based on 32,000, your lordship
Investigation
cannot
is
be a
going
household
on.
amount, your lordship. It cannot be deemed to be something that runs a criminal enterprise, your lordship.
Last page 24. This Malad, GP Malad, it shows that Malad 2 Devashish Achaji. So main culprit Malad given to this petitioner. So Malad, maybe he is selling these drugs, Malad.
That alone cannot be a ground for this, your lordship.
Anticipatory bail, Malad. Very initial stage,
I
Malad.
have come forth with the facts myself, your lordship. I could have not mentioned it, but I have come with good faith. I am ready to cooperate with the investigation.
You are Devashish Asarji.
Yes, your lordship.
Who is this Disruli Dolagopu?
This is the account name of the main accused, your lordship. As you will see on the top of the page, the main name is Moonbase 1000.
Invest 1,000.
Lordship will see the seizure also from my house. Nothing has been obtained except some money, your lordship, and not an extravagant amount, your lordship.
Twenty-seven A is their financing. Who is financing whom? He is getting the payment.
Yes, that is there, but he is getting the payment, perhaps he is selling other investigation, he has to be come up.
In other cases, but this relates to small quantity, otherwise main offense is bailable.
Already on, your lordship. I'm ready to cooperate, your lordship.
Had learned counsel for the petitioner and learned additional PP. This is an application under so and so. The allegation against the allegation as reflected in the FIR is that a small quantity of suspected heroin within bracket 3.17 grams was recovered from the possession of the co-accused Moonbase 1000 MOO and BESH THAOSEN. And in course of investigating the online transactions on the mobile phone of the said co-accused, if payment of rupees 4,000 was 4,400 from the said co-accused to the present petitioner was detected. And upon search of the house of the petitioner, an amount of rupees
2,300.
32,300 was recovered. Full stop. In the meantime, the main accused, Moonbase 1000, has been granted bail by the learned court below. At this stage, based on the available material, there does not appear to be anything to connect the present petitioner with the co-accused so as to attract section 27A NDPS Act. Whereas the section 21A smaller within bracket relates to small quantity and is a bailable offense. Hence, call for the CD, and in the meantime, it is provided that the petitioner, in the event of his arrest in connection with the aforesaid case, shall be released on interim pre-arrest bail of rupees 50,000 with a surety of like amount to the satisfaction of the arresting authority. It is further provided that the petitioner shall appear before the IO within a period of 10 days from today for the purpose of investigation. List again on
Lordship, can it be 14 days because next 3 days are holiday, might be difficult getting down there.
In that case, 25th of May.
I'm obliged.
Right. My lord, this is my lord PRS bill application and lordship will find at page 14 is the my lord affair. My lord, the gist of the case is my lord, the wetland was cutting by the my lord, drivers of the tractors, and two of the tractors drivers have been my lord, arrested. Sorry, my lord, three of the tractors drivers have been arrested. Now, basically allegation that my lord, they were cutting the my lord, wetland, and as such their tractors have been my lord, seized and the drivers have been my lord, arrested. Now petitioner before lordship is a businessman of the said locality and three is the my lord, Gaubra of the said area. They went there my lord, to my lord, settle the disputes between the police and the my lord, truck drivers, my lord, tractor drivers, but ultimately they have been my lord, implicated in the case. My lord. They have no my lord, involvement in the present case.
all right, CD.
Now, so far the wetland is concerned, it is my lord, bailable, but since it is met out, my lord, they have obstructed the police from their discharging duties, my lord. So this my lord, penal provision has been made. My lord. So my lord, CD may kindly be called for in the meantime, my lord, protection may be.
No, in the meantime, all of these are all syndicates going on.
My lord.
We are not taking any lenient view of this matter. Yes,
Can it be my lord, earlier date, my lord?
Earlier.
11.
11. Obliged.
Wait, please, your lordship. 482 bail application. FIR is at page number 10, your lordship. May I read the FIR? Page number 10, your lordship.
All right, CD.
From Dobokam, 13th of May.
Deeply obliged.
Admission activity.
Lordship, for the time being, Lordship, my senior is another court, Lordship, for some time.
Item number 12.
Maybe his lordship.
What is appearing? Any objection has been filed?
No, my lord. Earlier, my lord, at page 22, my lord, annexure B, page 22, annexure B, my lord, a case was not pending, title suit, my lord. And that was, my lord, disposed of. After that, my lord,
They filed complaint case, my lord. That is at page 14, my lord, Annex A. The cases of, my lord, of civil nature, my lord,
This is for quashing.
my question, my lord.
Any TCR has been called for?
No, my lord,
Not called for.
not wrong.
Failed on. Is it not necessary?
It's required, my lord. It's required.
Required.
Required, my lord. So this case, my lord, my prayer would be, my lord. The proceeding, my lord, in this case, may be state, my lord. Complaint case number 57 of 2023, my lord.
No, for that we have to be satisfied about.
Yes, my kindly see, my lord.
what is
Page,
going on.
page 22, my lord. Page 22, Annex B.
Page 23.
23, my lord, yes. Page 23, my lord. Nobakanto Boyso, the present petitioner, my lord.
No, what page 23 is a part of a petition. Miscellaneous petition under Order 9, Rule 13
Yes,
CPC.
yes, my lord. Yes, that case was, my lord, pending. It was disposed of, my lord. So we have filed an injunction, my lord. That was not granted. It was, my lord, dismissed there. And again, that, my lord, they have filed, my lord, RSA here, my lord. So, my lord, after that, my lord, they have filed a complaint case against me, my lord. That is at page 14, my lord. Page 14. Kindly see accused Navakanta Vaishya, my lord. Page 14, Annex A, my lord. Kindly see the accused, the present petitioner. The same plaintiff in, my lord, miscellaneous case, my lord. At page 23, my lord.
You are Novokanta Bushya.
My lord, my lord.
Complainant is this industry.
My lord. Look at sit. That miscellaneous petition, my lord, it has been disposed of, my lord. They are at Golpara.
Who is this Basudev Bakshi?
Basudev Bakshi is, my lord, owner of the garden, tea garden, my lord.
So you are the power of attorney holder of
My lord.
Bakshi.
My lord.
And his allegation is that the signatures are forged.
Force, my lord. That plea they have also raised there in, my lord, at Golpara before, my lord, learned, my lord, civil judge senior division, my lord. That was not entertained, my lord.
Huh?
When we filed this case, my lord, they have raised that question, my lord, but it was not, my lord, decided, my lord. After, my lord, the injunction, my lord, we have filed an injunction petition there, since the petition number 93 of 2022, that was dismissed, my lord. My petition was dismissed. So at this stage, my lord, my prayer would be, my lord, to call the LCR, my lord. In the meantime, my lord, the proceeding there, my lord, shall be stayed, my lord.
Where is the order in that miss case that you had, order 9 rule 13 application?
That order, my lord, I have not annexed, my lord. But we have annexed the, my lord, written statement filed by them, my lord, the complainant, my lord.
Here, your principal ground is that cases of a civil nature,
My lord.
but these are two different causes of action. Whatever original dispute between the two of you, this is the allegation is of forgery.
My lord.
It's not connected to the original dispute. Have to hear you. Okay, let us admit call for the TC and fix a date for hearing.
My lord.
We can't stay it because this is a different cause of action. Forgery. Learned counsel for the petitioner. None appears for the respondents. Pursuant to last order dated is 24/4/26. No reply or objection has been filed on behalf of the respondents. The petition is admitted for hearing. Call for the scanned copy of the TCR. Place the matter for hearing on. After 2 weeks, data did you?
Till then, my lord, the proceeding.
No. That's what we have said. Now we can't say. That is why we are giving it after 2 weeks.
A date will fix, my lord.
Timing at 11.
Obligement.
Wait, please, your lordship. And already there is a affidavit file. Probably my learned friend appearing as a amicus curiae for the, because it is a case of 376, my lord. Your lordship kindly see FIR page 28, my lord. Because just because I refused to marry her, that is why my lord case has been registered under section 376. Page 28, my lord, I'll read the vernacular.
Yes, read.
My lord, সন্মানপূৰ্বক বিনীত নিবেদন এই যে 6 মাহ মানৰ আগতে প্ৰায় নিম্ন উল্লেখিত পদকীয়াজনে মোৰ লগত প্ৰেমৰ সম্পৰ্ক কৰে। প্ৰেমৰ পৰা সম্পৰ্ক কৰি পদকীয়াজনে মোক বিয়া কৰা লোৱাৰ প্ৰতিশ্ৰুতি কৰি কাপোৰ কানি কিনাৰ কথা কৈ 18/1/2023 তাৰিখে দিনৰ অনুসমান 12 মান বজাত মোক ফুচুলে আৰু বিভিন্ন ধৰণৰ প্ৰলোভন কৰি কোকৰাঝাৰ থানাৰ অন্তৰ্গত কোকৰাঝাৰ টাউনলৈ লৈ গৈ বাসুগাঁও ওচৰ ষ্টেণ্ডত থকা লাইভ বিউটি পাৰ্লাৰত লৈ গৈ পাৰ্লাৰৰ ভিতৰত মোক জোৰপূৰ্বক ধৰ্ষণ কৰে। পিছত মোৰ সেই পাৰ্লাৰৰ পৰা ওলাই অহাৰ হাল্লা কৰাত সেই ৰাইজে পদকীয়াজনক আটক কৰে আৰু পদকীয়াজনে পলাই যাবলৈ সক্ষম হয়। গতিকে মহোদয় উক্ত ঘটনাৰ বিষয়ে তদন্ত কৰি বিহিত ব্যৱস্থা গ্ৰহণ কৰে যেন। মানে that was the affair my lord registered after 4 days my lord. 4 of these occurrence my lord. And my lord already charge sheet has been submitted. From the charge sheet my lord, your lordship kindly clearly revealed that my lord the version which was given by the my lord complainant my lord that is not supported by the charge sheet my lord. In fact medical also not supported. Now my lord what happened my lord, in fact I refused to marry her because she has already married person. I came to know that later on my lord, that's why I refused to marry her. And now my lord there is a affidavit shown by that prosecutors my lord, that my lord I have no objection my lord, they try to compromise the matter my lord. That my lord, that affidavit I have annexed and by way of affidavit I have filed before this honorable court my lord. And probably my lord she is not been appeared, that's why my lord first amicus authority is appointed my lord on behalf of the prosecutors my lord. So my lord what he has to say on my lord that affidavit my lord. Because
Where is that?
my lord affidavit but that is filed on my lord 24th November 2025 I have filed my lord along with the it start from the page 52 my lord, page 50 my lord, sorry. তুমি টেলিফোন পাইছা ইখন ভেৰিফাই কৰিব পাৰিম জানো যদি পাৰো কাৰণ যদি দেশত চিঠি লিখ
Yes,
so that affidavit my lord has your lordship got it my lord.
yes.
So my lord in such situation my lord whether it will be proceed with the matter my lord especially my lord the abuse of process my lord. Because she is my lord, the lordship kindly she is not a minor, she is a major. And in fact, my lord, I later on I came to know that she has already married. In that aspect, my lord, I have annexed one affidavit also, one my lord certificate from the my lord.
Where is that?
That certificate page 49, my lord. Page 49, my lord. So and under any circumstance, my lord, my lord, it cannot be my lord case of 376, my lord. Because if your lordship go by the my lord. Page 45, your lordship kindly see. Page 45, my lord. Page 44 and 45 of the my lord, that is the part of the charge sheet, my lord. The medical report, my lord. CL number 14, my lord.
Yes. Yes.
So my submission before your lordship, my lord, if he has anything to say regarding that my affidavit, who says I have additional affidavit, I have filed, my lord, along with the affidavit filed pursuant by the prosecuting, my lord. So on that, my context, my lord, your lordship, kindly, my lord, close down the matter, my lord. Because in the, even in a non-compoundable case, my lord, compounding can be done, my lord. That is meaning Nagendra Singh case as well as my lord, Prabhat Bhai case, it is already clearly mentioned, my lord.
You have the copies,
My lord.
the
My
case
lord.
you are referring to.
No, that is what one. That two judgment, my lord, that I have no copy, my lord, probably, so. The copy diana man, no?
Yes, other side.
I'll give the photocopy of that.
My lord, from the affidavit, page 54, she's already married to one Ayub Ali, my lord. Affidavit, my lord. So on by the victim, my lord, respondent number 2. I so and so wife of Ayub Ali, my lord. And at page 49 also the certificate annexed by the senior counsel, my lord. She was married to that same Ayub Ali on 12th January 2022, my lord. 2020, my lord. So that is the case, my lord, then no case to marry would be made out, my lord.
Incident of, incident,
It won't be mentioned.
incident of 2023. Now at the time of this affidavit, my lord, she stated her age is 23 years.
Incident when it happened, she was 22, man.
21.
22 years when the incident happened.
Major at the time of the
Major,
incident. But hard. PJ Mountain Learned Senior Counsel for the petitioner.
2007.
Learned additional PP also heard Mr. So learned amicus. Full stop. The instant criminal petition has been filed for seeking quashment of the criminal proceedings. In PRC case number 574 of 2023, pending before the court of the learned CJM Kokrajhar, Assam, arising out of a charge sheet number 295 of 23, dated 31/10/23, arising out of FIR dated 22/7/22 in Kokrajhar PS case number 269 of 2023 under section 420/376 IPC. The gist of the accusation, go to page 37. Upon completion of investigation, the IO has submitted the charge sheet. It is the contention of the petitioner that there was the love affair is admitted.
Yes, admitted. That is admitted in the statement also for last 6 months. rather than 30.
So the observations in the pre-arrest bail order that we can record.
My lord.
Yes.
And regarding non-compounding, compromise can be done in a non-compounding manner, that judgment, two judgment I in place, my lord, I'll give it. Parallel. Copy that.
Page 37, second para also. From
Edu. Parallel.
during the during the pendency of the present application, an additional affidavit has been filed by the petitioner, wherein a copy of an affidavit sworn by the alleged victim stroke informant has been annexed. Wherein it has been stated that during the trial of the case, that is sessions case number 57/2024, arising out of PRC number 574/2023, the matter has been amicably settled between the parties, and the informant has also executed a deed of compromise with the petitioner in presence of their guardians and witnesses, and that she has no objection if the accused person is acquitted of the alleged offense. It is submitted on behalf of the petitioner that the informant stroke alleged victim was already married to another person, because of which the petitioner refused to marry the informant. In the above referred affidavit sworn by the informant, she has described herself as the wife of one Ayub Ali, and learned senior counsel for the petitioner has drawn my attention to the Annexure 14 certificate issued by the ward member Govardhan Para GP, page 49, okay, stating that the informant was married to the said Ayub Ali on 12/1/2020.
Not only ward member, is a Gaon Panchayat president also, president Gaon Panchayat GP. That is countersigned by the government. Page 49.
Yes, and countersigned by the president of the said Gaon Panchayat. Okay. And the date of occurrence is, what is the date of occurrence? 23 somewhere.
23. It is my date of occurrence. Yes. 18/7/2023. 18/7/2023.
In view of the above facts and circumstances, it cannot be said that there was any deceitful act or false promise of marriage on the part of the petitioner. It is by now settled that though ordinarily in case of heinous offences, the power under section 482 is not to be lightly applied, but in a given set of facts and circumstances, the High Court has ample powers to invoke it, section 482 CRPC, to quash criminal proceedings even in case of heinous offences.
In that Nagander Singh, Pawar Bhai case, my lord, para 16, my lord. 16.2. 2017 9 SCC and another is 2014 6 SCC.
There are such powers of the High Court has been dealt with by the Honorable Apex Court in Narinder Singh and others versus State of Punjab and another 2014 6 SCC 466, as well as Pratap Bhai Ahir versus State of Gujarat.
2017 9 SCC.
2079 SCC.
641.
2017 9
9
SCC
SCC
641.
641.
Full stop. Para is already discussed. It appears that the informant and the petitioner were in a love relationship, and it was because of the already subsisting marriage of the petitioner of the informant that the petitioner refrained from proceeding with the marriage, and the affidavit of the informant referred to above also clearly indicates that the informant is no longer interested in pursuing the case, and in such circumstances it cannot be expected that she will depose against the petitioner in course of the trial. Trial has not started, has it?
Trial, my lord. Trial started, my lord, but he did not appear, my lord.
Full stop. Although the trial has commenced, it appears that the informant has not yet appeared to depose.
PW5, PW is like action or something.
I don't think trial has commenced.
The trial says comment, my lord, PW is, last order, my lord, I have seen the order that 18/7/25. Accused Mojawil agent is present, PWs are absent.
Order dated?
That is, well, you can see it. Certified copy of this order. This is the source. All the orders, my lord, take place. Shouldn't have. PW is there, the bottom.
Oh, this LCR is of May 24. So these 25 orders are not available.
It's 25. Oh, LCR to got more piece order.
As is apparent from the order sheet of the learned sessions court. In sessions case number T-2/57/2024, the certified copies of which have been submitted by the learned counsel for the petitioner. Where under the above circumstances, allowing the proceedings to continue would be nothing more than an abuse of the process of the law. Para, in view of the above, the impugned proceedings in so and so, I've already mentioned in case number so and so, are hereby quashed, and the petition stands allowed.
Maybe made a part of the record, my lord.
Yes, the
Yes, ma'am.
copies of the order, certified copies of the order sheet be kept as part of the record.
Obliged, my lord, highly.
Written, written.
Item number 13.
May I please, your lordship?
Yes,
To parents, the order dated 25 people. Pass by the order.
yes.
So, my lord, this is the case filed by my, revision was filed by my wife against me. I am 63 years old. My wife is also 60 years old. We had a love marriage and we have got 2 children. They're grown up major. But I gave my land to my wife, who is a working lady in school, high school, to take a loan and to build a house. Accordingly, on my land, he took a loan and built a house. I was living alone together, but I was ousted. But nowadays, she is not allowing to enter to the house. But all my documentary evidence, such as my lord,
No, who is before us?
wife has
My
come.
lord, kindly.
Wife has come. Let him submit. Madam.
Yes, yes. No, I thought you wanted to just point out something. That is why I asked. Yes.
My lord, actually what happened, my lord, their marriage was solemnized in the year 1993. And subsequently their marital life is as usually going on. And in between, after giving 2 children, one is about now 29 years and 25 years. One is working as under APSC as a gazetted officer, and son is also preparing for APSC. Such a situation, the respondent number 2, that is husband, always trying to quarrel and misbehave with the children, and as well
No,
as
what is the dispute here?
dispute here, my lord.
the petitioner subsequently filed a divorce petition. And after filing that divorce petition, after receiving that divorce petition, a false complaint case is lodged before the SDGM Gauhati.
So you are against the complaint
Yes,
petition?
my lord.
Where is that?
That is, my lord, in Assamese version at page 15, my lord. And translated version at page, my lord, 10. May I read, my lord, Assamese version?
Yes, read.
Page 15, my lord. Facts. ফরিয়াদীর বিনীত নিবেদন এই যে ফরিয়াদী আৰু আসামীৰ মাজত প্ৰায় 30 বছৰ আগত বিবাহ সম্পন্ন হয় আৰু তেওঁলোকৰ দুটি সন্তান আছে বয়স জীয়ৰী 27 বছৰ আৰু পুত্ৰ 24 বছৰ যোৱা প্ৰায় 2 বছৰমান আগলৈকে স্বামী স্ত্ৰীৰ মাজত সুসম্পৰ্ক আছিল তাৰ পিছত ফৰিয়াদীয়ে নজনাকৈ কাৰণবিহীনভাৱে আসামীয়ে ফৰিয়াদীৰ বিৰুদ্ধে এটি বিবাহ বিচ্ছেদৰ গোচৰ দিয়ে আৰু পাছলৈ 30/9/2022 তাৰিখে উক্ত গোচৰ নিজেই তুলি লয় উল্লেখযোগ্য যে ফৰিয়াদীয়ে যোৱা ইং 2006 চনত বিশ্বনাথ পূৰ্বতে শোণিতপুৰ জিলাৰ হেলেম ৰাজহ চক্ৰৰ চান্দামাৰী গাঁৱৰ লাহিতলী শ্ৰেণীৰ 212 নং দাগৰ 5 নং পট্টাৰ নিজ অংশৰ এবিঘা মাটি আসামীৰ নামত নামজাৰি কৰাই দিছিল যাতে আসামীয়ে উক্ত মাটিত আগলৈ কিবা গৃহ ঋণ ল'ব পাৰে উক্ত মাটিতেই ফৰিয়াদীয়ে নিজ উপাৰ্জনৰ টকাৰে বিয়াৰ আগতে নিৰ্মাণ কৰা ঘৰত আসামী আৰু নিজ সন্তান দুটাৰ লগত একেলগে সুখেৰে বসবাস কৰি আছিল কিন্তু পাছলৈ যেতিয়া আসামীয়ে উক্ত মাটিত গৃহ ঋণ লৈ এটা RCC ঘৰ নিৰ্মাণ কৰে ফৰিয়াদীৰ লগত কাজিয়া কৰি আৰু ল'ৰা ছোৱালীৰ ভয় ভাবুকি আৰু কুমন্ত্ৰণা দি ফৰিয়াদীক অসুখীয়া ও অকলশৰীয়া অৱস্থাত ৰাখি বলপূৰ্বকভাৱে উক্ত RCC ঘৰত বেলেগকৈ থাকিবলৈ লয় আৰু ফৰিয়াদীৰ লগত কোনো ধৰণৰ সম্পৰ্ক নাৰাখিবলৈ বন্ধ কৰিলে আৰু সন্তান দুটাকো তেওঁলোকৰ পিতৃৰ লগত কোনো ধৰণৰ সম্পৰ্ক নাৰাখিবলৈ বাধ্য কৰায় আনকি সন্তান দুটাৰ লগত ফৰিয়াদীকো লগ কৰিব আৰু কথা পাতিব নিদিয়ে ফলত ফৰিয়াদী আসামীৰ মানসিক আতিশয্যাৰ ফলত ভাগি পৰে আৰু অকলশৰীয়াকৈ জীৱন নিৰ্বাহ কৰিবলৈ বাধ্য হয় ফৰিয়াদীয়ে আসামীৰ সকলো আতিশয্য সহ্য কৰি পুনৰ আগৰ দৰে সুসম্পৰ্কৰ আশাত আসামীৰ বিৰুদ্ধে কোনো বিশেষ ব্যৱস্থা নোলোৱাকৈ থাকে বৰঞ্চ আসামীক প্ৰায়ে বুজাবলৈ চেষ্টা কৰি ব্যৰ্থ হয় এনেদৰে দিন অতিবাহিত কৰি থাকোতে ইং 4/12/2022 তাৰিখে নিশা প্ৰায় 9:30 মান বজাত মিছামাৰীৰ পৰা চন্দামাৰী নিজ বাসগৃহলৈ যোৱা অৱস্থাত ষ্টেলা মেৰিজ স্কুলৰ ওচৰত মটৰচাইকেল দুৰ্ঘটনাত পতিত হৈ অচেতন হৈ পৰে দাদাহঁতে আসামীক দুৰ্ঘটনাৰ খবৰ দিয়াৰ পাছতো কোনো গুৰুত্ব নিদিলে তথাপি ল'ৰা ছোৱালী হালকো ভয় ভাবুকিৰে ফৰিয়াদীৰ কোনো খবৰ লোৱাত বাধা দি ঘৰতে আবদ্ধ কৰি ৰাখে GNRCত চিকিৎসা হৈ থকাৰ সময়তো কোনো ধৰণৰ খা খবৰ বা যোগাযোগো আসামীয়ে কৰা নাছিল 12 দিন চিকিৎসাৰ অন্তত ফৰিয়াদী তেওঁৰ দাদাৰ ঘৰত থাকি ড্ৰেছিং ইত্যাদি কৰাই থাকে আৰু আসামী আৰু সন্তান দুটিৰ আঘাত বাট চাই থাকে কিন্তু আসামীৰ ষড়যন্ত্ৰৰ ফলত তেওঁলোকৰ কোনেও তেতিয়াও ফৰিয়াদীৰ যা যত্ন নকৰিলে তাৰ দুমাহ মানৰ পাছত ফৰিয়াদী দাদাহঁতৰ ঘৰৰ পৰা 7/2/2023 তাৰিখে দিনৰ প্ৰায় 4 বজাত নিজ গৃহলৈ যোৱাত আসামীয়ে তেওঁক দেখি বাৰান্দাৰ গ্ৰিলত তলা মাৰি ফৰিয়াদীক ভিতৰ সোমোৱাত বাধা দিয়ে আৰু ফৰিয়াদীৰ লগত কোনো কথা নপতাকৈ ঘৰৰ ভিতৰত সোমাই যায় ফৰিয়াদীয়ে বহু চেষ্টা কৰি নিজ গৃহত প্ৰৱেশ কৰিব নোৱাৰি দুখ মনেৰে পুনৰ মিছামাৰীত থকা উক্ত দাদাৰ ঘৰলৈ ঘূৰি যায় ঘৰত জোৰকৈ সোমালে পেট্ৰল ঢালি জ্বলাই দিব বুলি তীব্ৰ ভাবুকিও দিয়ে ফৰিয়াদীৰ উক্ত ঘৰত আসামীৰ তেওঁৰ ATM কাৰ্ড পান কাৰ্ড আধাৰ কাৰ্ড ভোটাৰ কাৰ্ড বেংক পাছবুক RC তথা ড্ৰাইভিং লাইসেন্স মাটিৰ নথি পত্ৰৰ লগতে
5,000 টকা আৰু নিজৰ পিন্ধন উৰণৰ সম্পূৰ্ণ কাপোৰ কানি আছে বৰ্তমানলৈকে ফৰিয়াদীয়ে আসামীক বহুবাৰ ফোন কৰি যদিও আসামীয়ে ফৰিয়াদীৰ মোবাইল নম্বৰ ব্লক কৰি ৰখা বুলি জানিব পাৰে আগতে কেতিয়াবা বুজাবলৈ চেষ্টা কৰিলে বা ফোন কৰিলে আসামীয়ে ফৰিয়াদীক তুচ্ছ তাচ্ছিল্য কৰি নানান অশ্লীল গালাজৰ দ্বাৰা ফৰিয়াদীক অপমান কৰি হীন প্ৰতিপন্ন কৰাৰ চেষ্টা কৰে আসামীৰ উক্ত ব্যৱহাৰৰ ফলত ফৰিয়াদী নিৰুপায় হৈ মিছামাৰীত থকা তেওঁৰ উক্ত দাদাৰ ঘৰত বৰ্তমানলৈকে বসবাস কৰি আছে আৰু ঘৰত আৰু আলমাৰীত থকা উক্ত অতি প্ৰয়োজনীয় সামগ্ৰীসমূহৰ পৰা বঞ্চিত হোৱাৰ ফলত দৈনিক নানা অসুবিধাৰ সন্মুখীন হৈ আছে আৰ্থিক অনাটনৰ ফলত নিত্য প্ৰয়োজনীয় দৰৱ ইত্যাদি কিনোতে বহু কষ্ট হৈছে কাৰণ আসামীয়ে ফৰিয়াদীক উক্ত সামগ্ৰীসমূহ নিবলৈ দিব লাগে বুলি ক'লেও আসামীয়ে কোনো ভ্ৰক্ষেপ নকৰে আৰু মৰিলেও চিন্তা নকৰে বুলি কয় ফৰিয়াদীৰ শংকা হৈছে যে আসামীয়ে তেওঁৰ উক্ত সামগ্ৰীসমূহ নষ্ট ও অপব্যৱহাৰ কৰিব পাৰে সেয়ে ফৰিয়াদীয়ে এই সংক্ৰান্তত যোৱা 4/2/2023 তাৰিখে হেলেম থানাৰ এখন এজাহাৰ দি ন্যায়ৰ আশা কৰিছে যদিও আৰক্ষীৰ দ্বাৰা কোনো বিশেষ সহযোগ নোপোৱাত বাধ্য হৈ মাননীয় আদালতত এই আবেদন দাখিল কৰিছে After getting that information, petitioner approached the police station whether any FIR was lost or not. And as per police report, no any FIR was lost. And after received this notice, he continuously appeared before the trial court for adducing evidences, etc., etc. And this petition filed only create pressure upon the petitioner, as because petitioner initially filed a divorce petition due to quarrel between them. And
That was before the complaint petition.
before complaint petition, my lord. Two divorce petition, one filed and subsequently the opposite party tried to reunion. And on that assurance, earlier one was withdrawn. And after withdrawal, his behavior so harsh. And subsequently, she filed another petition, which is now under defense witness stage. And after filing the second divorce petition, the opposite party filed this false complaint case against the petitioner. And in this case, my lord, the daughter of the petitioner, son and daughter, both adduce evidence in trial court in this complaint case. Kindly see page, my lord, 103, my lord, in my additional affidavit.
They adduced evidence
As it is adduce evidence as deposition of witness number 3 in the
for the complainant.
before trial. Yes, for the complainant.
So sons are with him.
Daughter and son with the mother.
You said they deposed for the complainant.
My lord, the son and daughter called by the court.
Say that.
Say that, my lord, and recorded their statements, which is, my lord, at page 103, my lord.
One zero three.
My lord. 103.
103 of what?
103 of, my lord, in my additional affidavit.
Don't see any additional affidavit here.
Have you got it, my lord?
Nothing is here. Court master, additional affidavit assigning is also. It's 10 কিবা কৈ আছে এটাতো এখনতো ইয়াতে আছে এডিশনাল এফিডেভিট ক'বাত আছে নেকি ইয়াত কৰা কিবা মেনশন আছে নেকি You haven't filed any additional affidavit.
On the last occasion, it was available with the file. Please give me.
I did.
No, my lord, it is.
Then how could it have been there on the last occasion?
LCR is also there, maybe with the LCR. As because my lord, on the last occasion, I read it.
What do you remember?
Remember?
It was there.
No, I don't.
So he's not supporting you.
That is also with my friend, my lord, and on the last occasion, I also read it before the court, my lord.
My lord, I think, have you finished? You finish it? Then I will submit.
How can he finish? Additional affidavit is not here.
But the fundamental thing, this case is there. It is there between husband and wife. My lord, house was constructed, no doubt, but with the loan money of this SBI. Now I am not allowed to enter in the house. That is the dispute. And my all valuable documents, like such as passbook, PAN card, Aadhaar card, election card, all are with her. She is not allowing to enter. And this the son said that son said that it is not
This document, it is
not
possible to.
not safe to be stayed with my father.
And it is filed, my lord, 11/12/2024.
And now trial is going on again because there is
What is the section under which the case is proceeding?
It is, my lord, section raise, my lord,
Yeah, what do you think? That is applicable.
341, 294, 506, 111, 113, 406.
Because my all
From the
valuable
reading of
is
the
return
complaint,
my
I am
goods,
yet
my
to
lord,
find
I will
one
put
section.
case. Let him return my goods.
Yes, why don't you return his documents?
As because, my lord, those documents with not me, my lord.
It is in the Godrej.
And they.
Who has the
Partly-
keys to the Godrej?
In my wife's custody, my lord.
My
If
lord-
I could enter, I could bring it and I can bring up.
Second party living,
Gate is locked. I am not allowed to.
it is very clear, my lord, from the FIR, from the complaint, he is living with his elder brother.
Yes.
And entire documents with him.
No.
And he has so many landed properties. About 35 bighas of land.
If I die,
Nothing
you will
has been
get
done.
everything. If I die, you will get everything.
Nothing.
Why not?
If you had, if that be the case, that these documents are like there, you could have filed an appropriate application before the court below seeking those documents.
I'll file.
And if those, this is happened, these are the civil nature of case, they.
No, not civil nature.
file
It is not civil
recovery-
nature.
Once you
recovery-
get your document, your grievance is over, no criminal offense remains.
Yes, my lord.
So we list this after 1 month. In the meantime, you file appropriate application before the court below,
Well, give that observation.
get an order,
Yes, I will. If you-
search the house, find it.
Yes, finish. No need. If he wants to divorce me, I will be happy with that. But my life is at stake to live with her.
Very good.
He's
Another
not
case-
allowing me to enter in my own house, own landed house. No, is out, man.
So we can dispose of 2 cases.
Yes.
Divorce as well as this one.
Divorce also I am not objecting, my lord. Divorce she is getting. Let she get let she be happy with the divorce, my lord.
So let her learned counsel for the petitioner and learned counsel for the respondent at some length. An additional affidavit said to have been filed on behalf of the petitioner is not on record. Registry to verify and place the same on record on the next date fixed. In the meantime, respondent shall be at liberty to file appropriate application before the learned trial court for the purpose of obtaining custody of the documents said to be lying in the custody of the petitioner. List again on. Four weeks or piece of detail.
I have to
4
sign
weeks.
copy.
28, May,
20th May.
28. Item number 40.
Obliged. May it please your lordship. My lord, for quashing proceeding, my lord, quashing of a DFE case, my lord. Your lordship kindly see, my lord, petitioner number 1 is the husband, my lord. And petitioner number 2 is the brother-in-law. He's a doctor, my lord, he's suffering from cancer. And petitioner number 3, my lord, is a retired, he's a father-in-law, my lord, 77-year-old. And petitioner number 4, my lord, 69-year-old mother-in-law. So if your lordship go by the plain reading of the, my lord, FIR, the complaint, my lord, all the allegation against, my lord, here in this case, my lord, there is a stay order operating in respect of 2, 3, and 4, not against the husband. In respect of others, my lord, stay order operating. If your lordship go by the, my lord, that complaint, my lord, all the allegation and all the relief sought for against the petitioner number 1. Your lordship kindly see complaint start from page 24, my lord. So your lordship kindly see page para 3, my lord. Direct the respond number 1. Direct the respond number 1. All the claims against respond number 1. That means my lord, husband. So against other family member, that thing, my lord. Only one line is there, my lord.
Who is the husband? Ashraf Ahmed Laskar.
My lord. Petitioner number 1, my lord. And all relief sought for against the, my lord, petitioner number 1. And my lord, one line, my lord, in the last para of the complaint, my lord. Page 37, my lord. That the aggrieved person has suffered severe mental agony, emotion, trauma, and harassment due to the cruel, negligent, and abusive behavior of the respondent number 1. She has been willfully neglected, mentally tortured, emotionally humiliated, and physically assaulted by the respondents. Only that line, my lord. So, my lord, my submission before your lordship, now I pay before your lordship, even my lord, there are several judgments of the apex court also. That, my lord, let the against the husband go on, my lord. But other member, my lord, your lordship kindly, they are old, the retired persons, my lord. And in fact, petitioner number 2, he is suffering from cancer, my lord. So they are, my lord, direct to die. Equally, my lord, very same that they have filed a criminal case also. That
As against them, it is already stayed.
my lord, there is a state, my lord. There is a stay order in respect of this too. No, he won finally disposal. That's why I'm arguing, my lord. Probably today for final disposal. Other 3% there is a stay order is operating, my lord.
I will not. I think we have given you one disposal today. Will not give
My lord,
another.
sorry, my lord, sorry. No, all my, no, I am agreeing, my lord, but my learned friend is, my lord, subject to his self.
So let's post it for hearing then. Hardly, Mr. T.J. Mohanty, learned counsel, the petition. Snow as learned counsel appearing for respondent number.
Sole respondent, my lord. Sorry, my lord, respondent number.
It is shown as
Second, respondent number 2, my lord.
respondent.
1 is the state of Assam, my lord.
So hard. Learned additional PP for the state. Anything is required to be called for?
In this case, only the complaint was there and the order of issuance of notice was there. Both of those are on record, my lord.
Upon hearing the parties.
Is for a date because one of the reasons is that because it is stay for 2, 3 and 4, the proceeding.
List the matter for hearing on given date. If interim order passed earlier shall continue till the next date of listing.
Deeply aware.
21-5.
For hearing, my lord.
Deeply aware.
Supplementary 52.
Wait, with the lordship. Petition under section 482 CRPC is for quashing of an FIR lodged way back on 25/2022 under section 406, 468 and 420 IPC. Before that, your lordship, on the last occasion, there was a direction for up-to-date scan copy of the case diary.
So I think it is here.
It was there, but updated was not there. So there was a direction for an updated.
Yes, now this is April 24 has been sent.
Yes, April 2000.
It is here now.
Up to date.
Yes, because it is dated in April 24.
Now it is April 26.
No, 24th of April.
Or 24th April 2026.
Yes.
Oh, then it is, yes. It is there, your lordship.
Why was it necessary?
Now, lordship. Before coming to the FIR, your lordship, this petitioners and the private respondent number 2, both are through a common descendants. And they have inherited the properties of their.
I don't think we can go for disposal today. Either we admit and fix for hearing or fix for admission hearing on another date. The whole bail hearing list is there. Hearing.
Up to him, lordship, hearing or admission.
Lordship, may fix a date, your lordship, for hearing.
Admission hearing or hearing?
For admission hearing, it may be disposed of an admission hearing also.
And counsel for the petitioner and counsel for the respondents. The updated PCRS call for has been received. List the matter for admission hearing again on.
Obliged.
Obliged, lordship.
Just 5 minutes. Yes.
Lordship, I filed this petition for granting regular bail petition to the petitioner in this case, lordship. FIR is a page number. Page number 10, lordship. May I read, lordship? With due respect and humble submission today, that is 21/11/25 at about 3:30 PM, my daughter, namely Gitanjali Bonia, is sitting in front of the gate. Then no one was present in my house. At the time, the accused person is going to close to her and gave 10 rupees note in her hand and calls her inside our house and with her intention to physically assault her inside the room.
Yes. Yes, PP.
This is a voluminous case diary, my lord. So, my lord, there is a, my lord, for the note prepared against each and every accused person of the, my lord, of this bail application, my lord. So, lordship may kindly peruse, my lord, the I just mentioned the, my lord,
All right, you pass it over, we'll see that. Any submissions to be made then?
No, we have been cooperating,
We are
my lord.
cooperating,
We have been cooperating.
Let it come at 2 p.m. my lord. I have to make my submission, my lord.
All right.
Police, my lord, there's report of the investigating officer, my lord. Second paragraph onwards, my lord, after my lord, from page number 4, my lord. When the, my lord, the person executive, my lord, sales executive of the, my lord, Vodafone Idea, my lord, they are also involved in this case, my lord. They have provided, my lord, all the infrastructure, my lord, then, my lord, in collaboration with the other request person, my lord, they have seated many people, my lord. That report, my lordship, may kindly peruse, my lord.
Including honorable judges,
Yes.
doctors, lawyers.
So it is a big scam, my lord. So this matter, my lord, although they have got interim, my lord, but I pray, my lord, their interim protection may be rejected, my lord. Let the investigation be continued and complete, my lord.
Have you marked against the present petitioners?
Page number 4 onwards.
Okay, we'll have to examine.
Lordship.
Yes,
but
make your
only
submissions.
Submission is that, my lord. We are granted interim, my lord. We have been cooperating with the investigating agency thoroughly, and we have not violated any bail condition. Lordship knows, my lord. We have not violated any bail condition, my lord. We are there, we are ready to cooperate the remaining part of the investigation, my lord. And there is not, we are in jail, my lord. We are in custody, we are thoroughly interrogated. After that, we are granted interim bail, my lord. And now, my lord, the cancelling our bail and again asking us to surrender, my lord, will not serve any purpose. We'll cooperate for further, my lord. If lordship puts a stringent of condition, my lord. That is my humble submission before your lordship. And my same with item 18, 19, 20. And my 21, my lord, my learned friend, there is no interim in respect of one of the petitioner. I don't know, 21. There is Moon Kalita. He has
55 days behind the bar, my lordship.
and he is 55 days behind the bar. There is other accused. There were two petitioners in item number
55.
55 days, item number 21, my lordship. Moon Palita not granted interim.
I mean, item number 21, there are two
21, how many petitioners?
two petitioners.
One is Moon Kolita.
Moon Kolita has not been granted interim bail, my lord. The other one has been granted interim.
There was granted interim, my lord, only to appear in the examination, my lord. That is why he was granted interim, my lord.
But all of us have been thoroughly, my lord. We have been cooperating with, and whenever the investigator calls us, my lord, summons us, we appear, my lord. And there is possibly there is nothing more to investigate, my lord.
All right.
Obliged, my lord.
Shall I hand over the entire case diary, my lord, along with it?
Yes, okay.
For item, these people were, my lordship, arrested on 8th of March. All these people, all are arrested. They were remanded to police custody for 2-3 days, thoroughly interrogated, then they were sent to judicial custody. Subsequently, due to non-availability of the case diary, they were allowed to go on bail back. So they have already served in jail. They have served in jail, my lordship.
Obviously, these are regular
Bail
bail
applications.
applications.
Document confirm. Again, what?
My lordship. Item number 21, my lordship, I am appearing. My item number 21, I am appearing, two petitioners. One petitioner earlier honorable court granted bail and Moon Palita is not granted. Is behind the bar 55 days. Kindly my lordship consider.
55 days.
55 days. Mandatory period is 60 days, my lordship, in this case. Kindly consider, my lordship.
All right.
Obliged.
22, my lord, I am there. Item 22, my lord.
All right.
25.
25. Thank you. So here was the case diary, case diary was called for, my lord. My lord, I am page 24, my lord. My lord, that arrest memo, my lord, no signature of the attesting witnesses is there, my lord. That's the ground, my lord. Page 24, my lord. 24 and 25, my lord. Two accused are there. The last three lines, my lord, the signature of the accused. And my lord, from below the second line, my lord, W2 message white so and so has been sent, my lord. The relative, whether it has been sent and acknowledged by the family members or not, my lord. That has to be seen from the diary, my lord. That two part, only those two.
Yes, any material in the CD to show?
The message also there, my lord, that is, my lord, I have just put a flag mark, my lord. It goes to-
Arrest memo.
Yes. So distributed to W2 message, my lord, and this is the 48 notice, my lord.
Acknowledged question.
পিছত prosecution কথা order decision mandatory ছিল আগৰ কেছটো যিকেইটা ফাইলটোতে আছে নেকি চাবচোন মই পাছ কৰা আগৰ কেছ একেলগে থৈ দিব গোটেইকেইটা একেলগে ৰাখি দিব জাজমেণ্ট কেইটা
Paragraph কিমান আছে? এইটো কি?
Yes.
And my lord, the arrest memo, whether there is any attesting witnesses or not, my lord, that to my, it's not there in my file.
I think this will be similar to that earlier case where Mr. Mahajan appeared.
My lord, this honorable court, my lord, order, my lord, that BA number 887 of 2026.
Well, I am really sorry. And I am relaying a judgment of a court, my lord. My lord, that Dr. Sangeeta Datta's case, my lord. Paragraph 30, my lord. Internal page 16, my lord.
All right.
Internal page 16, paragraph.
Okay, we have noted, Wills. Have you passed the judgment?
My lord, I'm obliged, my lord.
My lord, that.
এই judgment টো ৰাখি থৈ দিব। সেইটোৰে এটা
I submit letter.
One more judgment I'm also giving. One.
I think we have fixed the other case for fifth, I think. Since the matters are interconnected, should we fix it? Okay, let's see. I might keep it as CAB also.
Fine.
For delivery of orders.
You will be required, ma'am.
It will be required. Yes, it will be required.
No.
27.
Wait, please, your lordship. Lordship, I'm behind the bars since 9/2/2026. It is today the 80 day, lordship, and there is no such materials against me, evidence against me. There is a only 14,000 and 14,500 something rupees, which 14,650 rupees on that was seized in my custody, on which basis it was the IO has implicated the section and section 27A of NDPS Act, and there is there is nothing against it applicant to establish the connections and establish that he is a supplier or he has some connections with that NDPS. Lordship, if Lordship peruse who's the last phase of the order of this application, bail application, page number 42, where it is also stated that there is no such ingredients is found, and IO has nothing. IO has submitted nothing against the applicant. And
How has
during the-
NDPS come in? Liquor is recovered.
Liquor is covered, Lordship. Yes.
Then how NDPS? What section of NDPS has been?
Lordship, when I was arrested, Lordship, on 8/8/2026, then on the basis of the statutory violation, I was released on bail on a PR bond of rupees 10,000. It was fined in page number 23, Lordship. And thereafter, accordingly, the learned court below has directed me to appear before the police station to record my statement. And when I went to there to record my statement, they arrested me. And on the basis of that, there were a new section has been added, that is section 27A of the NDPS Act.
But the case diary come, because we do not know why this section has been added, my lord.
Plus, one more submission is that there's then 48 notice has not been served also.
No, after your arrest, you were forwarded by this forwarding report dated 8/2/26 at page 18.
Lordship.
Maybe in here, there is no mention of any contraband drugs.
So that is why, my lord, that Lordship may fix it next week, my lord, any date, my lord.
And the NDPS section is not mentioned here also.
Lordship.
In the forwarding report also.
Lordship.
Then where has it come from?
Lordship, on the next day when I was released on bail on PR bond, then next day they have added on the section 27. Lordship.
Where is that? Where is that? That they have added?
Lordship,
Where is your release order? First order?
first release order, Lordship will find at page number 23, Lordship, on the top, that accused is allowed to go on bail by furnishing PR bond of rupees 10,000 in default to judicial custody. Then thereafter, Lordship, page 27, annexure 4, that the second paragraph, on perusal of the case diaries in CDR and other materials on the case diary, it appears that the sufficient materials allowing adding the section 27A NDPS Act and section 3(5) of BNS in this instant case. Thereafter, when I went there to police station to record my statement as per the order dated 8/2/2026, then they arrest me.
From the page number 24, my lord, these articles it is not come under the NDPS Act, my lord. Page number 24, my lord.
The Caesar, there is no NDPS.
Why, my lord, this
That is what material the magistrate found to permit adding of NDPS.
This is why, my lord.
I think it must be only because of recovery of money.
Money lordship.
When
50
recovery of money also, my lord, the 27.
It will not come unless there is
Will not come, my
some recovery.
Lordship.
My lord, that's the case that we call for, my lord, so immediately, my lord, next week, my lord, any day. my lord.
Lordship, moreover, the statutory violation provisions has been violated, Lordship. 48 section notice not served, Lordship.
No, statutory violation, that was earlier.
Lordship.
And in that case, you were released. Subsequently, you were arrested again.
Subsequently, Lordship, when if Lordship peruse the order dated 10/2/2026, it is in the page in 29, page number 29, it is said that the IO has duly communicated on the grounds of the arrest and to the accused person in Assamese language under section 47 of BNSS as 3:45 PM yesterday. That is more than 2 hours from the productions of the accused. Therefore, the court this court and the same is compliance with the judgment passed in the Honorable Supreme Court is Mihir Rajesh and so and so.
Page?
And page 29, Lordship. And also family members of the accused person have also been communicated on the ground of arrest. 48.
So where is the violation?
Lordship, 36 notice, 36 in the
Again, IO has complied with section 36B2 BNSS at the time of making arrest, it says. Second paragraph from the bottom,
Lordship.
page 29.
Lordship.
So the compliance is there, it seems. Prima facie.
Lordship. Prime.
Now, what we are concerned is with how did 27A come in?
But there is nothing indications and which was
How long in custody?
80 days, Lordship.
Huh?
80 days, Lordship.
80 days.
Lordship. Today is the 80 day.
It appears to be prima facie. Because the magistrate has not indicated anything about what is the material against him under the NDPS Act. Is sufficient material.
Lordship, in the rejection order, in the rejection order, there is nothing indication about the section 26.
I heard learned counsel for the personal learned additional PP. This is an application under so and so. CDS called for has not been produced today by the IO. The case was initially registered under section 112 BNS read with section 53, 54, 63 of the Assam Excise Act. As per the seizure list and forwarding report, no item covered under the NDPS Act appears to have been recovered from the possession of the owner petitioner. Subsequently, however, on the prayer of the IO, Section 27A of the NDPS Act relating to financing has been added. However, there is nothing in the prosecution documents or in the orders passed by the learned magistrate to indicate as to on what basis the prayer for adding Section 27A of the NDPS Act has been allowed. As of now, there is no material before the court to determine as to whether Section 27A of the Act, NDPS Act, is attracted in the facts and circumstances of the present case. Where a learned additional PP prays for further time to produce the CD, which is allowed. However, having regard to the period of detention of 80 days already undergone by the petitioner, and in view of the absence of any indication regarding any material attracting Section 27A of the NDPS Act, I am inclined to allow the release of the petitioner on interim bail. Full stop. Accordingly, the petitioner so and so be released on interim bail of rupees 50,000 with 2 sureties of like amount to the satisfaction of the which court?
Lordship, Sipsagar, Lordship. Lordship, additional
okay, we'll say additional.
Subdivisional judicial magistrate Nazira Sipsagar.
No, last order was passed by additional session judge FTC Sipsagar.
Sipsagar, Lordship.
Yes. Additional session judge FTC Sipsagar. In connection with the aforesaid case. Where it is further provided that once released on interim bail, the petitioner shall continue to cooperate with the investigation and shall not try to hamper the investigation or tamper with the evidence in any manner. Release the matter again on
20 to 5. Lordship. Deeply obliged, Lordship.
28.
May please your lordship. So this is a case under the Cattle Preservation Act, my lord. The petitioner number 1 and 2, my lord, they are the driver and the co-driver. 3 and 4 are the laborers, my lord. In a 6-wheeler truck, my lord, 22 numbers of cattle were found, my lord. The petitioner is in custody for 43 days. My lord, we have filed an additional affidavit bringing on record the charge sheet, my lord. Charge sheet has been submitted. Now case has been already committed to the court of the additional session judge, my lord, Pokrajar. So even if we assume that the allegations which are leveled are true, my lord, already the committal is over, my lord, the trial is about to commence. As may not be a case, my lord, which would require under trial custodial detention of the petitioners, my lord. Already 43 days in custody, my lord. The FIR, your lordship will find at page 16, my lord.
Yes.
Submitted, my lord, the TCR, scan copy of the TCR may be called for, my lord.
No, trial.
Allegation is what? Transportation.
Transportation, my lord.
22 numbers of
22
cattle
numbers
were
of cattle.
recovered.
Yes, now in having regard to the nature of the offense, what is the further detention needed? So investigation is over. Heard learned counsel for the petitioner, learned additional PP. This is an application under so and so. As per the allegations, the petitioner was petitioners were, how many?
4 petitioners.
Were apprehended while transporting 22 numbers of cattle. And accordingly, they were arrested and remanded to custody. Where the charge sheet in the case has already been submitted and the case has also been committed. And the case is therefore ready for consideration of charge. Para. In the meantime, the petitioners have spent 43 days behind bars and having regard to the nature of the allegations, their further detention is not considered necessary. Accordingly, the prayer for bail is allowed. 50,000 1 each. Satisfaction of the learned.
Additional sessions as spoken as well.
Condition deal will cooperate with the trial.
I'm deeply obliged.
29.
Please, your lordship. Lordship, is a regular bill application, FIR page number
Yeah, Mr. Item 40 Mati Divu.
13, your lordship.
Item 40 here, Mr. Mati Divu.
A thief in an under construction building. Already recovered, your lordship, stolen goods, but not from my position, your lordship. I was arrested on
This is
11th.
Magistrate Tribal.
My lord?
Magistrate
Yes,
Tribal.
your.
So you can appear there. Huh?
Yes, your.
With heard learned counsel for the petitioner and learned additional PP, it is stated that CS has already been submitted by.
Yes.
CS.
2026, dated 31/3/26.
It is submitted on behalf of the petitioner that the petitioner shall appear before the learned court below and apply for regular bail. Oh, you are in custody.
Yes, your honor, I have 50 days, your lordship, to do. Behind the budget.
Don't say petitioner shall appear, the petitioner shall file appropriate application before the learned court below. And hence it is the instant bail petition is disposed of with the observation that in the event of such application being filed, the same shall be disposed of as per law. Bail petition stands closed accordingly.
আপনার item 40.
Yes.
I'm grateful, my lord. When it did get called, my lord, we were sitting there and not realizing, my lord, the matter's been called.
Yes.
Well, the well, the main thrust of my learned friend's argument is one, my lord, they say that, my lord, they again argue, my lord, on the question of transfer and transmission. My lord, recall, my lord, transfer and transmission, that, my lord, it's a operation of law. And my lord, secondly, they argue that they say that please give it to us, we will not transfer it. That seems to be, my lord, the second, my lord, argument, my lord, which they make. Now, my lord, my first submission is, my lord, the transfer and transmission issue is no longer relevant. Because the transfer and the transmission issue arose in view of the order of 24th September 2025, which had stated that do not transfer the shares, that he should not transfer the shares. And when we came back to say that
no, you put it back, you have transferred the shares, you put it back to the account where it existed, there, my lord, the question of transfer and transmission had come up. So now, my lord, it's no longer a question of transfer and transmission. My lord is hearing out the appeal. The appeal is against the order of 15 September 2025, which dismissed, my lord, my injunction application. So with great respect, my lord, to my learned friend, this transfer and transmission is no longer relevant. That was only in the context of, my lord, recalls, my lord. 24th September, the order was
Acted in violation, then they.
well, 24th September, the order was not to transfer. Resolution number 2, not to transfer the shares. So when they suppressed that order and got the, my lord, transfer done, they came back and argued, no, which resulted, my lord, in the order of 28 January 2026. When they got that order, my lord, then they came and argued that no, it was actually a transmission, not a transfer. Therefore, we are not liable. Now, my lord, kindly look at, my lord, what we had asked for. I do not understand, my lord, this with great respect, my lord, my learned friend's submission that give it to me and I will not transfer, because he is yet to establish his right as owner of the share. It is not a question of transferring it to him or her in this case. It's a question of, my lord, whether, my lord, the shares exist with the estate till, my lord, it is decided as to who is the owner. And kindly, my lord, this is very important. Kindly, my lord, look at, my lord, my petition and the praise which was made. My lord, this is in the appeal. The FAO, main appeal, my lord. My lord, will find, my lord, the plaint.
The memo.
In the memo, my lord, huh?
Page 28, you print the start with.
Sure.
Then page 40.
Sure, memo na stay out.
Stay to memo to stay there.
আমার তো এখানে স্টে লেখা রয়েছে।
Another page of
স্টেতে কত, মেমোতে কত আছে?
memo.
My lord, page 28. My lord, kindly look at, my lord, the plain prayers and kindly, my lord, look at the petition prayers, my lord, which is, my lord, the originally as prayed for. Very important. My lord, at page 40, my lord, will find
Page 40 of?
my lord, the memo of memorandum of appeal, my lord.
FAO 62.
FAO 62.
Okay, yes, go on.
Declaration that the plaintiff is the sole and absolute owner of 861,918 equity shares of the defendant number 1, which is now lying in the demat account bearing DPID 301151 and client ID Sansaj in the name of the plaintiff and the defendant number 2 maintained by the defendant number 3. Then decree for mandatory injunction directing the defendant number 2 to execute, sign the delivery instructions form and submit to plaintiff for transfer of the said 861,918 equity shares in the sole name of the plaintiff. Then perpetual injunction restraining the defendants from transferring the shares from the existing accounts maintained by the defendant number 3 safe to any demat account standing in the sole name of the plaintiff. Then perpetual injunction restraining, perpetual injunction restraining, dealing with disposing of. Now, my lord, so this is, my lord, the plain prayers. Now, my lord, kindly come to, my lord, the petition prayers, my lord, which is at page 212. So my learned friend, I don't know why, my lord, criticized the status quo order which was passed. The status quo only was in relation to, my lord, the shares which was then lying in a particular dematerialized account, which belonged to, my lord, the estate. This is, my lord, at page 212.
Yes, of the injunction petition.
Of the, my lord, yes, my lord, prayers of the injunction petition. This is, my lord, I'm showing from the memorandum of appeal.
Okay.
My lord, page, kindly, my lord, look at, my lord, page 212.
Yes.
In the premises aforesaid, this is the original prayer I came with. In the aforesaid premises, it is therefore prayed that your honor would be pleased to pass an ad interim injunction restraining the opposite party number 2, her servants, workmen, opposite party 2 number, my lord, is, my lord, the Shormila, Opposite party number 2, her servants, workmen, employees and agents from causing any transfer, then matlab cheez in whatsoever nature in respect of 861918 shares of B&A Limited lying with opposite party number 3, matlab, which is HDFC, in its account bearing number DPID 300301151 and client ID 2645 son such. And further you restrain the son such. And matlab, this is matlab, what was restored by the order of my Lord's Court on the 28th of January 2026 and which was matlab, affirmed by the Honorable Supreme Court.
Yes.
So today, my lord, the submission made that let me transfer it to my own account and I shall not transfer is a meaningless submission with great respect to my learned friend. That means he is defeating the purpose of the suit itself. My lord, nothing stops me from saying, please give it to my account, I shall not transfer it. Because my lord, we are both claiming to be owners. And the prima facie case is in my favor because, my lord, I have the person who held the shares saying that, no, I did not want to give it to my daughter. That's, my lord, the Supreme Court which I showed, 71 Supreme Court. And, my lord, it fell from court, my lord, that it's like really like from the horse's mouth. So today, my lord, and kindly, my lord, look at, my lord, the will, which is, my lord, at page, my lord, 265 in the same, my lord, memo.
Yes.
Page 265, my lord, at 266. Clause 2.2. The said certain 861918 shares, my lord, this is what, my lord, the Bodua is saying, my lord, Mr. Bodua is saying, number of equity shares of B&L Limited above are held by me with my daughter Shurmila, who is the second holder. The entire consideration for acquisition of such shares was paid by me and no part of such consideration was paid by my daughter. And my daughter has no beneficial interest in such shares. I have applied before the Company Law Board for removal of her name. I have also filed a title suit for declaration that declaration the matter that said such shares limited before in a petition filed by me arising out of said title suit. An ad interim order of injunction has been passed. Then, my lord, clause 5.0, very important. At page 271. I give, devise and bequeath my entire shareholding in BA Limited as mentioned in para 2.1 and 2.2 above, being acquired as the promoter during public issue of shares from mergers as well as purchases from open market, equivalent exclusively out of my own funds, capital and savings for Hemen Borua Benevolent and Family Trust absolutely and forever. So under the will, my lord, it is given to the family trust. So till, my lord, the right is adjudicated, the defendant can't say that give me title to the shares. Today, my lord, the defendant is saying give me title to the shares while the matter may be pending, but in the meantime, let me have it.
Altering the status which was subsisting.
And then, my lord, clause 6.1, my lord, there's a, at page 272, there's a specific direction, my lord, that she is disinherited. Whatever, my lord, the legal effect of that, my lord, we are not concerned with it now. And it says, by her action, my younger daughter is trying to invade into my right over 861918 equity shares, manifestly acting in illegal, unscrupulous manner. And this is all gone to the family trust.
Which she wants personally.
Now, my lord, there is a SEBI circular, my lord, of 18th October 2021, because my learned friend, my lord, relied on, my lord, the NSDL rules. NSDL bylaws.
SEBI circular dated?
My lord, SEBI circular, my lord, dated October 18, 2021. And kindly see, my lord, clause 3. Heading, my lord, says transmission of securities to joint holders.
all listed companies. Yeah.
Well, this is B&A is a listed company. In regard, RTAs are hereby advised, 3, to comply with the aforesaid provision Companies Act 2013, transmit security in favor of surviving joint holders in the event of demise of one or more joint holders, provided that there is kindly similar, nothing contrary to the same in the articles of association of the company.
Yes.
Now, my lord, in the articles of association of the company, which my lord will remember was challenged by the respondent number 2, my lord, by filing that company petition 186, which my lord got dismissed
In 2013.
in 2013. There, my lord, kindly look at my lord article 43, which is my lord at page 424. No, it is there in the book. No, but it's there in the paper book. My lord, we also have a separate copy of the entire articles.
Mention the paper book page.
My lord, in the appeal, my lord, it is there. Page, my lord, 424 and article 43.
Yes.
My lord, 43, article 43(2). It says on the death of a member who was the first named joint holder on the register of members, his successors, if he is single, or one of his successors, if there are more than one, as may be jointly nominated by successor, shall be substituted as the first named joint holder in his place. The surviving joint holder or holder shall continue to be recorded as second or subsequent named joint holder. Which means, my lord, today, if Mr. Borua passes away, then my lord, the executor, who is my lord, looks after the estate, my lord, under the Succession Act. He is, my lord, the legal successor of my lord, Mr. Borua. He will have to be substituted. It is not that, my lord, it will go to her. And respondent number 2, my lord, will continue to remain as the second named holder. And why it is relevant, kindly, my lord, come to article 78, which is, my lord, at page 426. And, my lord, internal page, my lord, 19 of, my lord, that entire bunch, my lord, we have given. At
Clause 78.
my lord, clause 78 provides, my lord, where there are joint registered holders of any shares, any one of such person may vote at any meeting.
Page 19.
Page 19 of, my lord, that articles which I have given, my lord, internal page 19 at the top, my lord, will find, my lord, the
Yes.
pages.
Clause
Clause 70, article 78, where there are joint registered holders of any share, any one of such person may vote at any meeting, either personally or by proxy, in respect of such shares, as if were solely entitled thereto. If more than one of such joint holders, then kindly similar, be present at any meeting, either personally or by proxy, that one of the said person to present whose name stands first on the register in respect of such shares shall be alone entitled to vote in respect thereof. So, my lord, what does this mean, my lord? This means that if there is a first named holder and a second named holder, and both are present, then the first named holder will vote. And, my lord, it is an admitted position. I will just show that letter. It's an admitted position that, my lord, for the last, when the matter, my lord, when the shares have come to be held, my lord, in first named holder and second named holder, my lord, respondent number 2 has never exercised voting right in respect of the shares. Never. Has never received any dividend in respect of the shares. Till date. And has exercised no right, my lord, in respect of the shares. It has always, my lord, been in the joint account. So today, my lord, by the death of, my lord, the first named holder, they can't get any added advantage. Because, my lord, the suit is pending. Suit is pending. It clearly says that unless you are able to show that the shares were meant to be gifted to you, you have no right. You are not the owner. You cannot come to court. Today, my lord, they want a positive order from my lord, saying that please direct the authorities to transfer it in my name. That's, my lord, what they want. It should, my lord, continue to, my lord, exist or rest where my lord, it is for all these years, which is the account 301151, which is my lord, what happened, my lord, on the 20th of January. Now, my lord, I've shown the will. Now, my lord, my learned friend relies, my lord, on table F. My lord will recall, my lord, handed over in table F of the Companies Act. Now, my lord, table F in schedule. My lord, unfortunately, my lord, table F doesn't apply. Table F, my lord, is when the company adopts table F, which was, my lord, under, my lord, the Companies Act 1956. It was described as table A.
In 2013,
And it is, my lord, a general articles. If, my lord, company doesn't adopt, my lord, any articles, then, my lord, they can follow that articles of association. Here, my lord, the company has its articles of association. And that, my lord, will find, my lord, in the same, my lord, the articles which are, my lord, handed over at
page 2, clause 2. Now, where does it say that this table F is whatever you have submitted?
Yes.
That company may adopt this unless
My lord, yes, my lord, I will show, my lord, kindly look at, my lord, the articles, my lord, which is there.
page 2.
My lord, page 2, my lord, which I have shown. Article 2, my lord, is not in the paperwork. We have handed over, my lord, the complete articles. Save as reproduced herein. The regulations contained in table A. Now, my lord, under the 1956 table A, my lord, was.
Put the A, now F again.
Now it is F. Save as reproduced herein, the regulations contained in table A of the first schedule to the Act shall not apply to the company. My lord, has that, my lord, Article 2.
This memorandum of association, where is the articles?
My lord,
articles starts from which page?
My lord, articles, my lord, are page 8. After page 7, my lord, will find page 1 and page 2, my lord, it says articles. After the first 7 pages, my lord, again it starts with page 1, my lord, will find articles of association.
A has become F. Yes. Two.
Yes, my lord, Article 2. So no one has adopted table F.
Says if full day. 56. Last. Yes.
My lord, in the 1956 Act, my lord, table A at that time it was referred to as table A was under Schedule 1. So that's, my lord, a general article. Unless you adopt it, it does not apply. Now, my lord, সেকশনে কোথায় বলছে টেবিল এফটা অ্যাপ্লাই করবে দেখো Well, I'll just give Mullah those relevant photocopies of Mullah those table A originally under the company 956 and Mullah table F now, which Mullah my learned friend has given. So Mullah, our submission is Mullah that unless and it specifically excludes the general articles because it has its own articles of association. And 43 read with 78 Mullah, 43(2) says no, only the first named holder will be substituted. And that's what their challenge was also to the articles. Mullah remembers Mullah on the first day Mullah I showed the company petition where the first prayer was declared him as the owner of those shares, which is now dismissed. And then Mullah there was a challenge Mullah to the articles, Mullah the amendment to the articles. Now Mullah, so Mullah my next submission is Mullah the NSDL rules do not apply because Mullah there is a dispute Mullah with regard to Mullah the shares themselves. It's the ownership Mullah of the shares Mullah which is Mullah in question. So unless Mullah ownership is established, there is no question of Mullah the Mullah there's no question of Mullah the My lord, there's no question of, my lord, exercising any right in respect of the ownership of the shares. Now, my lord, just my lord to, my lord, I'm just followed that article's point, my lord, since my lord asked me, my lord, section 5, subsection 5, my lord, subsection 6, my lord, can you have a look at, my lord, the Companies Act? This is 2013, 1956. Can you look at, my lord, article 5, sorry, section 5?
Yes.
Section 5, subsection 1. The articles of a company shall contain the regulations for management of the company. My lord, has that, my lord? Then, my lord, 5, 6. Articles of a company shall be in respective forms specified in tables F, G, H, I, and J in Schedule 1 as may be applicable to such company. Then, my lord, see 7. A company may adopt or all or any of the regulations contained in the model articles applicable to such company. So, you have to specifically adopt it.
Section 56 Act.
And exactly, my lord, similarly, just give. My lord, similarly, just give section 28. You have to adopt these articles, my lord, for it to be made applicable. My lord, can you see, my lord, the 1956 Act, my lord, I've given. Under section 28, 1, my lord, sees 28, 1 too. Or, my lord, the old Act, because, my lord, this company, my lord, is under, my lord, the old Act. Can you, my lord, look at section 28, 1?
Yes.
My lord, see, adopt any of those days, my lord, it was only, my lord, table A. So these are, my lord, model articles which one company can adopt. Under the 1956 Act, my lord, it was table A. And under the 2013 Act, my lord, it is, my lord, tables F, G, H, I, and J. And so far as, my lord, this company is concerned, it specifically says we are not adopting. That's article 2 at page, my lord, 2 of the articles of association of, my lord, this company B&L Limited.
Yes.
Now, my lord, kindly look at, my lord, I'm sorry, my lord, I'm just going to trouble my lord once, my lord, with the one letter, my lord, contemporaneous letter of, my lord, Borua at, my lord, page 155 of, my lord, the stay application. My lord, IA 3216. My lord, this is dated 1st September 2011. And, my lord, there is no dispute with regard to this letter. These letters are all, my lord, accepted. My lord, father writing, my lord, to respond number 2. Page 155, my lord, of stay application 3216. IA 3216. It says you are aware that on 12 November 2008, dear Shormila, my lord, the letter is dear Shormila, transfer of 861918 shares. You are aware that on 12 November 2008, I had transferred 861918 shares of B&A Limited to our joint demat account in HDFC Bank. DPID number 301151. Such transfer was made by me purely for operational convenience and you had no beneficial interest whatsoever over the said 861918 shares. Notwithstanding such transfer, the said 861918 shares continued to be owned by me and were shown as such in my income tax records. You also never claimed that the shares or any part or portion thereof belong to you. I desired to retransfer the said 861918 shares in my name and accordingly I have sent in such and such form to transfer the shares to my DPID account, such for the following address. I request you to sign the form and return the same to me. And my lord, there's also my lord, page 161, writing to the bank as well. So, my lord, I am showing, my lord, a prima facie, more than a prima facie here, my lord, because the person, my lord, who had the shares himself filed the suit also. To say, my lord, ownership of the shares only vests, my lord, with him. If that is the case, then, my lord, my respondent number 2 cannot take advantage of his death and then say, I want to alter the status. It is not a question of you transferring, it's a question of whether you can claim or exercise any right of ownership. And I'm grateful, my lord, a question fell from the court as well, that transfer means, if it is transfer, transmission, whatever it is, if it goes to you, that means in effect, you are entitled to exercise all rights in respect of those shares. If I, my lord, understood, my lord, the court correctly, that was, my lord, the question fell. And I'm grateful, and that's exactly, my lord, what our submission is also. To answer, my lord, if I was to answer that question, I said, that's, my lord, the crux of the matter. Whether, my lord, while, my lord, ownership is, my lord, in dispute and, my lord, is being decided by court, you can get right to the shares. It is no concession. I don't want any concession to say I'm not going to transfer the shares. I am also not going to transfer the shares. If it comes to that, my lord, I am also saying I am not going to, as, my lord, executor, as the estate, I am also not going to transfer any shares, my lord, unless, my lord, this suit is decided. It is not a question of concession. That is not the issue at all. Question is, my lord, whether the shares at the time when, my lord, the suit was filed was in, my lord, a particular DPID account. That's fact 1. Fact 2, there was an order of injunction or status quo, whatever it is, which kept the shares in that account. Fact 3, plaintiff died. Fact 4, executor has been substituted. Fact 5, the Supreme Court has not disturbed, my lord, this order that, my lord, it should remain, my lord, in that account twice. Then, my lord, am I wrong? With great respect, my lord, if I put my argument in a question form, am I wrong, my lord, to then request the court that while the suit is pending, now suit has also been expedited. We have taken steps, my lord, to have the suit, my lord, expedited, and, my lord, the trial of the suit, my lord, to start as soon as possible. That till it is decided, it will continue to remain in the same state. Same state. That is, my lord, the question, my lord, which the court has to decide. Now, my lord, and also, my lord, kindly, I have already made that, my lord, submission. Kindly, my lord, make a note, my lord, of that order, my lord, also passed, my lord, by the High Court, whereby, my lord, the dividends are, my lord, being, my lord, directed to be deposited in the estate account. Separate, my lord, estate account of, my lord, H. Withdrawal.
That was dated 27th June.
My lord, order is, my lord, 27th June 2018.
Memo of appeal, page 395.
My lord, memo of appeal, my lord, page 395. My lord, you'll find prayer B is there. That's, my lord, where, my lord, the direction was given. Now, my lord, kindly look at, my lord, my learned friend, my lord, relied on, my lord, a 2023 NCLAT judgment. Now, my lord, very important. My lord, kindly look at, my lord, that judgment. My lord, though, my lord, it's a tribunal, appellate tribunal judgment. High Court, my lord, how much, my lord, they will, we'll look at it, my lord. I don't know, but anyway, my lord, kindly look at it and kindly see, my lord, paragraph 2. This is 2023 NCLAT 648. SCC online NCLAT 648.
Yes.
My lord, Gunjan Sharma, kindly look at, my lord, paragraph 2. In brief, if my lord has a copy of the judgment.
We had, I think it's got buried somewhere. We'll have to extract it.
My lord.
Anyway, you read, we'll note
Very
it
well,
down.
my lord. My lord, I want to make, my lord, 3 points on that. First, my lord, paragraphs 2, 3, 4 and 10, my lord, will find it shows that, my lord, there was a will which left the shares to, my lord, this particular, my lord, lady, Kashvi Parashar. Daughter, my lord, that's the daughter, my lord, of the testator. And, my lord, at paragraph 10, I'm reading out, very important. The learned counsel for respondent Kashvi Parashar mentioned that the respondent father Sri, paragraph 10, Gagan Parashar and his wife Preeti Parashar divorced in July 18. Younger daughter Kashvi Parashar continued to live with the father and his former wife Preeti Parashar, and elder daughter Kashish Parashar started living separately. He has further argued Sri Gagan Parashar owned Southern Sat 45,000 equity shares in Sanivi Construction Private Limited, and Kashvi Parashar submitted an intimation for transmission of the 45,000 shares held by her father under section 56(2) of the Companies Act, attaching therewith no objection of her mother Preeti Parashar and elder sister Kashish Parashar in her Kashvi Parashar's application. Further submit after death of Sansaj. So, my lord, no one objected. That is one of the most important thing. The company was refusing to transfer. And the NCLAT said, my lord, under exercising powers, my lord, knows under section, my lord, 56, my lord, and 58 and 59, to say that you can't object because it is left by the will to the daughter, Kashvi, the other heirs, the mother, and the elder sister have given no objection. That is, my lord, the basis on which, my lord, this my lord, transmission, transfer, whatever it is, my lord, was allowed. Now, my lord, in our case, and that's why, my lord, the learned, my lord, the court below went completely wrong. My lord, in the 15th September 2025 order, my lord, I'll just take, my lord, once to that. That is, my lord, impugned order at page 412. My lord, just kindly have a look, my lord, page 412. And, my lord, kindly look at paragraph, page 421, part of paragraph 20. Internal page 10, my lord, of the order, page 421, my lord, otherwise, part of paragraph 20. This is what, my lord, the court, my lord, the learned trial court, my lord, has recorded. The shares which were maintained in a separate account of the petitioner, which is, my lord, the petitioner means, my lord, Borua, in ICICI Bank were only transferred to the joint account. OP number 2 is one of the children of the original petitioner. Then, my lord, very important. Other children or their legal heirs have not challenged the right of OP number 2 in respect of this 861918 number of shares in a joint account. As the said 861 not the trust properties. I hold the balance of absolutely wrong. Because the will gives it to the trust. In the will, they've all given their no objection. Their consent affidavit, my lord, to the probate application and, my lord, to the will. All, my lord, 3 of the other heirs. The elder daughter, wife of, my lord, PDC's son, granddaughter, everyone, my lord, has given no objection, a consent, not even no, my lord, it's a consent to, my lord, grant of probate of that will, which means the shares, my lord, have to go to the trust. The only one objecting, my lord, is this daughter. That, my lord, will find, my lord, I had shown it, my lord, when I'm just giving, my lord, those page numbers, my lord, of consent affidavits, my lord, will just kindly, my lord, make a note, my lord, at, my lord, page 301 of, my lord, the appeal. 301 right up to, my lord, my lord, up to 317 of my lord, the appeal. All the my lord, consent of the other heirs are there so far as my lord, the shares are concerned. So my lord, it is with great respect, my lord, it has been wrongly held by my lord, the trial court that other heirs are not objecting to the transfer of the shares. Because their rights will get trampled. Today, my lord, giving it away to one daughter, contrary to the probate application, contrary to the will, contrary to my lord, the order subsisting in the suit, my lord, will be my lord, absolute my lord, injustice. Now, my lord, kindly, my lord, just 71 Supreme Court type of thing. My lord, the 71 Supreme Court which had already relied upon. My lord, kindly just make a note, my lord, of that paragraph 21. It's been already relied upon.
Para 21 of?
My lord, para 21, my lord, of AIR 71 Supreme Court 1962. Sorry, my lord, paragraph 22 and 23. And this is, my lord, what caused, my lord, the court to make that comment as well, my lord, at that time. Sorry, 21, may I read, my lord, just, if my lord has that, my lord, 21. The transfer with which we are concerned in this case cannot be given because Dr. Pandit continued to be owner of the amounts in question till his death. There is no presumption of advancement in this country. But yet, if there has been satisfactory evidence to show that the transfer in question are genuine, and further that Dr. Pandit intended that the amounts in question should go to the first defendant exclusively after his death, we would have held that the advancement put forward has been satisfactorily proved and the presumption rebutted. Then 22. It was for the first defendant to establish that there was a general intention on the part of Dr. Pandit to benefit him, and in pursuance of that intention, he transferred the deposits to the joint names of himself and first defendant. If he had proved those facts, he would have made good his plea. Then my lord, see Sanasaj Privy Council. Then 23, in Guran Datta vs. Rima Datta, Privy Council held that the depositor made by a Hindu of his money in a bank in the joint names of himself and his wife, and of the terms that it is to be payable to either of the survivor, does not on his death constitute a gift by him to his wife. There is a resulting trust in his favor. In the absence of proof of a contrary intention, there being in India no presumption of an intended advancement it in favor of a wife, same views expressed by the Judicial Committee in such and such. And this, my lord, they say is also, my lord, for all other relatives, my lord, which is the Privy Council, my lord, judgment. So, my lord, my submission is today, my lord, we have a case where my lord, there is evidence to show that respondent number 2, my lord, cannot claim ownership. If respondent number 2 cannot claim ownership, there is no question of today, my lord, exercising any right. Any right. My lord, in respect of, my lord, those shares. And my lord, just one, my lord, we also, my lord, the proposition of law, my lord, perhaps, my lord, I don't need to, my lord, burden, my lord, the court, my lord, with any cases, but if required, my lord, we'll give, my lord, the judgment. The proposition of law is that, my lord, when a suit is filed and when there's a dispute with regard to title with regard to a property, then it is the purpose of the interim order is to maintain the status which was existing as on the date of the suit. Because it is there. That is why, my lord, the status quo order, it's not that, my lord, all courts, my lord, pass orders of status quo, including, my lord, the Honorable Supreme Court. It's a question that while the suit is pending, the rights should not be disturbed. And here, my lord, admitted position is that these shares were lying in DP ID 301151. It cannot be taken away during the pendency of the suit. And particularly, my lord, when you yourself asked for a title with regard to the shares in the company petition and you failed. And here the will is there. Why should, my lord, with great respect, I'm sorry, my lord, I'm putting my argument question. The other rights of other people, other heirs, the trust. You can't trample over it while, my lord, the suit is pending. So, my lord, the status has to be preserved. My lord, there's only that one judgment, my lord. I can give a copy, my lord, to my learned friend, my lord. I'm sure, my lord, that there should not be any dispute, my lord, with regard to this proposition, my lord. There's 1992 supplemental 2 Supreme Court cases, 651, para 126. Para 126. Which, my lord, says the existing state, my lord, should be.
What was that, 1992?
My lord, 1992, 2 Supreme Court cases.
Supplementary.
Sorry, 1992, bolo.
651.
Supplementary 2 Supreme Court cases, my lord, 651.
Supplementary 2.
Supplementary 2 is, my lord, 651, para 126. Okay. Okay. My lord, those are, my lord, our submissions, my lord, in rejoinder, my lord. My lord, if it's my lord's, I don't know, my lord, whether notes, my lord. My lord, once, my lord, any, my lord, further, my lord, notes or anything, my lord, from us, or otherwise, my lord, we are.
Yes.
Because, my lord, on the first day,
She has sold the property.
because, my lord, there are also other, my lord, we are apprehensive, there are other, my lord, contempt proceedings, which I have also mentioned in the first day, my lord. Mother's property, my lord, has been sold, there are contempt proceedings pending against, my lord, the daughter, my lord, lot of, my lord, other issues are there. My lord, those, my lord, are.
Yes.
My lord, my lord, kept, my lord, to my.
Promise.
I don't know, my lord, whether that makes me a good lawyer or a bad lawyer. My lord, I'm told good lawyers, my lord, are supposed not to, my lord, stick to, my lord, this time, my lord. I'm grateful, my lord. I'm extremely grateful, my lord, for very.
Posterity will decide.
My lord, very patient hearing, and my lord, sorry to trouble my lord all this, my lord, days. I'm grateful, my lord.
Yes, Mr. Muzumdar, what else is left?
Nothing is left, my lord. My learned friend has argued certain things which were not initially argued, so I have to.
No, I argued everything. My lord, all, my lord, I'm only replying to my learned.
No, nothing, my lord, about the judgment, interpretation given to the judgment, I have to clarify 2 paragraphs. I'll come to that first, my lord.
That anklet.
Yes. It is being projected that there was a no objection, and it is because of the no objection that ultimately transmission was permitted. Well, factually, it is not correct. If your lordship reads paragraph 10, I'll be very brief, my lord. If your lordship reads paragraph 10 of that judgment, it was projected that there was no objection. But that doesn't mean that the transmission was allowed because of only considering that there was no objection. And that will be very clear from paragraph, my lord, 24 and 25. Lordship will permit me just to point out 2-3 sentences from there, my lord. It is because of an intimation under section 56 that the transmission was done, not because there was no objection, as is sought to be projected, my lord. I am just reading 2 lines, my lord. Here, we also consider the argument of learned counsel for appellants that a settlement data so was entered into by Karshvi Parashar, their mother Preeti Parashar, and uncle Gagan Sharma. We are of the clear view that the settlement is not relevant when a letter of intimation under section 56 of the Companies Act is under consideration. This is important. The provision Companies Act section 56 2013 Act is very clear it distinguishes between transfer and transmission. Transmission, it says that it is by operation of law, and moment the intimation is given, the transmission has to take place. Whereas transfer of share is by an instrument of transfer.
Yes, we have heard you on that.
My lord, I'm just saying that the judgment is very clear that this transmission was permitted in this case, my lord, by the appellate tribunal, not because there was no objection as is sought to be argued. It is because intimation was given and it is by operation of law. This is my first one, I'm just clarifying. And the initial opening statement by my learned friend was that transfer and transmission, distinction between these two concepts, my lord, has become irrelevant and is not relevant. My humble submission before lordship is, my lord, this transmission was done in this case. This honorable court in the application under 3983 under section 151 came to a conclusion that there was violation of the order initially passed by this honorable court. However, it is whether it is a transfer or transmission that will be decided in the violation petition. That was not decided.
No, we have not pressed.
Now, what I am submitting before lordship is, it is because of that some court said no, it has to be reverted. And that is till IA 3982 is decided. Now the question is, my lord, today your lordship is deciding application under order 39 rule 1 and 2, and your lordship is examining whether the prayer for injunction directing me or prohibiting me not to transfer it to a third person, which is transferred by instrument of should be allowed or not. We say that we have got no objection because we have no intention to sell it to a third party. Now, so far as transmission is concerned, our prayer is that transmission has to take place by operation of law. That need not be prohibited because that is neither their prayer nor are they entitled to that kind of order. Because in between something has happened, it was reverted, and they are not entitled to that order because it is not their prayer. Their prayer is that it should not be transferred to a third party by me.
No.
That I am saying that yes, I am not transferring.
No.
Lordship may always grant. But this transmission, they cannot pray because it has to take place by operation of law.
But this is their petition. If we say that transfer back the shares to them, then we are granting him a relief indirectly, which we have not come in appeal or praying for that.
It is their application. In their application, their prayer is that we should not transfer.
We limit ourselves to their prayer.
Yes.
Why should we grant you a?
Yeah. What I'm saying is, their prayer is whether it should be transferred, whether I should be restrained from transferring or not.
No.
But the prayer now sought to be made is taking advantage of the order passed in the interim, that status should be maintained. That will be beyond their prayer matter. Because allowing that would amount to disregarding section 56 of the program, which says that transmission has to take place by operation of law. That they are not entitled indirectly, which they are not entitled directly.
All right.
We've shown the prayers, my lord, what we restrained to that same account.
And just one more submission about the articles of they say that we have adopted. We have not adopted the
Table F.
in the articles of association in the table F, but we have our own. In their own, they have used the expression or they are taking advantage of the expression executor. My lord, assuming that executor is the executor of a will, although it doesn't say, my lord, probate is yet to be granted. You have not become entitled to the property. What is your status today? You have got a will in your hand, nothing else. Will is yet to be probated. So far as I am concerned, I am a joint holder. I have made the provisions, my lord, read the provisions. It is very clear that in the absence of one of the joint holders, the surviving holder is entitled to transmission by operation of law. He is recognized to be the owner. NSDL rules are very clear.
They have accepted as an executor because we've been substituted in the suit.
That is a different
Otherwise, we
thing.
couldn't have
You
proceeded.
are substituted in the suit, but
I am the plaintiff
even
in the
if any
suit.
decree is passed, that decree is not to be enforced until a probate is granted. But here you are taking, my lord, here is a case where what they are praying today is that you are entitled to remain in the house, don't sell it to a third party, but during the pendency of the suit, don't use the house also.
No, no.
That cannot be the prayer. I am,
Not your
if
house.
I am entitled to the house presently, I have to use the house. You want to prevent me from using the house also. The title of the house is yet to be decided.
House is not in your possession.
That is the prayer, my lord.
Grateful. My lord.
All right.
Extremely grateful.
I think your book is here. Your books are here.
My lord, that can, my lord, we can give copies of that.
Yes,
And
yes.
my lord, we can make copies. And my lord, the entry order, my lord, can continue, my lord, till my lord passes, my lord, the.
CAV interim order to continue till verdict.
I am extremely obliged and obliged.
May I please your lordship? After that case, there was call from madam.
Here, my lord, those CPs received, my lord, their statements, my lord, not is available. My lord, interim is granted, my lord, earlier, my lord, but I have seen the certified copy of the order, but the statement of the two petitioners is not available. Short accommodation, maybe I'll bring the statement, my lord.
They appeared.
They have appeared, my lord. Lordship may give a short date, my lord. I will obtain instruction, my lord.
All right. Yeah. It is submitted by learned additional PP that the statements of the petitioners said to have been recorded by the IO are not available in the CD. Hence, list the matter again on so and so to enable learned additional PP to
My lord, on
obtain the same purpose.
12, my lord.
There is an interim order, my lord.
Interim order postal date to continue.
31.
Obliged.
Bail application, lordship, we are already on interim, but the matter is charge sheeted, so TCR will be required, lordship.
Surface is also not complete, I believe.
Service also not completed.
Submitted, the CS has already been submitted and charge sheet. And the number is there.
Already, my lord, scan copy call, my lord, number, my lord. Yes, Shashi, they have annexed, my lord. Page
Yes,
49.
TCR will be required, your lordship.
TCR is required. TCR not yet.
Charge sheet has already been submitted in this matter and hence the scan copy of the TCR will be required. Accordingly, call for the scan copy of the TCR.
Interim order is there, your lordship.
Also await service report. List again on so and so. Interim order passed earlier to continue. Next date.
19.
Date?
19.
It is 19.
32.
There are also on the last occasion, the scan copy of the charge sheet was called for. Only the 183 statement of the victim girl has been received. Nothing is there in the scan. copy. Only the statement of the victim girl has been received in the scan copy, nothing else. And he is already on interim.
And duly cooperating with DPS.
No information regarding whether he has appeared.
Nothing.
No, actually, CD part is not there.
Also, let's say POXO is there, so the respondent number 2 also has to appear.
I don't think you have taken steps. Office note does not indicate so. Respondent number 2. Had learned counsel for the petitioner and learned additional PP. Scanned copy of the TCR has been received, but the CD is not available. So reminder for the CD. It also appears that no steps have been taken for service on respondent number 2 as per office notes. Petitioner to take steps within 3 days without fail by speed post AD. List the matter again on interim order passed under to continue field the next.
Lots of interim order.
Yes, yes.
34.
CD has not been received. Earlier rejected by Lordship, CD was called for, it has not been received.
Well, this is second time. And co-accused have been granted bail. Of course, they were in custody for certain days. And my lord may kindly see page 20.
It's first date, not second date. CD was called for on 23rd and
Today's second
this is
time.
second date.
Police has himself said that investigation has been sufficiently progressed. That is page 20. In February, this report was sent. So thereafter now May, my lord, sorry, my lord, April 30. So more time police has got. And moreover, I have been suspected only. FIR is very much clear. I have been suspected. I suspect that he is involved in this case.
No, I beg to differ, Lordship. In your Lordship's rejection order at page 17, Lordship has already observed that he was the main culprit. And that he
I am telling about FIR. Kindly see page 9.
FIR is way gone, Lordship. Now we are talking about the case there. After perusal of the case there, Lordship has indicated.
That was long time back. Already police himself said that investigation have been progressed.
Will produce the case there, Lordship.
And my lord, page 9, kindly see the last part. Only I have been suspected by the mother of the deceased. Under any condition, we will cooperate with the investigation.
We'll have it immediately next week. Fifth. CD has called for, has not been received for the second occasion today. List the matter on 5/5/26. In case the CD is not produced on that day, the prayer for interim bill shall be considered. List again on 5/5.
Highly obliged.
35.
interim আছে তো? কিন্তু এই যে appear হয়নি।
কি হয় না?
appear হয়নি।
May I please, as your lordship? My lord, I am on interim, my lord. Even I have the instruction that I went to the police station to appear and cooperate with the investigation, but the IO, my lord, has not recorded my statement till date, my lord. And 3 times I have approached the IO, my lord. And secondly, my lord, pursuant to my lordship's interim protection, my lord, I have also applied for Jimma of the properties, my lord, and the learned trial court below has, after perusing all the records, my lord, has given Jimma of these, my lord, properties, my lord, can, if my lord has vehicle along with the, my lord, buffalo, my lord. But the buffalo has not yet been released, my lord, and therefore we have again come up with a petition, my lord, before this honorable court, my lord. Allegation of theft was there, my lord, which is absolutely not correct, my lord. Yes, PP.
As per note of the IO 12/4, interim was granted on 6/4. 12/4, there is a note of the IO that stating that he was asked to appear before the IO on 11/4, but he has not appeared. That is a note. Subsequent to that, it is not after that he has appeared or not, that is not reflected in the CD. And yes, my lord, as it is not verified, the regarding the buffalo, my lord, Zimma was not granted, and only regarding the vehicle that's given, my lord. But there is no note, my lord, though diary is up to, my lord, 15/4, there is no note that he has appeared, my lord.
When did you appear according to your? My lord, immediately after the bail order, my lord, on the very next day, I went to the police station, my lord. My instruction is that. And now, my lord, thereafter 2 times I went to the, because, my lord, I have to visit the police station with this order, the Jimma order, my lord, and that has also been handed over to the IO, my lord. Now, if my lord may be pleased to peruse the order, my lord, which I have not make a part of the record, my lord, may kindly have a look this order, my lord.
If that is the condition, my lord may record the statement of the learned counsel. I will convey the message.
My lord, my lord.
If that is the, my lord, his client went and is not recorded, then if he record his statement, my lord, I will convey to the, my lord, IO, my lord. Otherwise, my lord, statement may not be there, but at least, my lord, appearance note, that should be.
On that day, I appeared the IO. Counsel for the petitioner submits that pursuant to interim protection granted on 6/4/2026, the petitioner had gone to the police station for recording his statement, but the same was not recorded on that day. And even on subsequent dates, when the petitioner went to the police station in connection with the Jimma of the seized articles, his statement was not recorded. Learned additional PP submits that there is no note in the CD which is up to 15/4/26 as to whether the petitioner has appeared. Accordingly, the learned additional PP is to take instructions in this regard. Is the matter again on when 7th? 7, interim order passed earlier to continue. Mal.
36.
Obliged.
Lordship, CD has been received, but the service of notice, Lordship, that is awaited. No information has been received.
May it please your lordship, we have taken steps.
There is no office note also regarding service of note, informal. Informal. Oh. The informal.
CD is received. CD is received, but service on respondent number 2 is not yet.
Your Lordship, they are appearing for respondent
Also,
number
they are appearing for two. They are.
You are appearing. You filed. All right.
Lordship, in 482 anticipatory bail application, FIR is at page number 10, Your Lord. Matter pertains to POCSO, Your Lordship. May I read the FIR? Sir, I would like to state that 6 months.
The CD.
Deeply obliged.
If you have not been received.
Wait, please allow. My lord, this matter was moved on 28th. Otherwise, Lordship was pleased to fix it on 5th. Now, my lord, due to, my lord, apart from that, there are certain additional facts which we could not bring to a Lordship's notice while moving the petition on 28th. So we have brought on record those documents by an additional affidavit. Now, my lord, this is a affidavit, this is a case where the allegation is that during the time of election, my lord, that the petitioner has resorted to certain acts which constitutes offense in the meaning of, my lord, rioting, voluntarily causing grievous hurt, assault, undue influence, then mischief and criminal intimidation. Now, my lord, basically, this is an FIR lodged to keep the petitioner away from the counting day on 4th. Because I was the candidate for the Indian National Congress. My lord, in fact, we filed complaint before the police, we filed complaint even before the Election Commission of India, and we also demanded an inquiry into the whole thing. My lord, otherwise, my lord, on 4th, my counting is there. If I am not present, my lord, then, my lord, his purpose is served. The ruling party's purpose is served. Now, my lord, at the time of election, I don't dispute that at the heat of the passion, my lord, some overt act may have been done. But we are not criminal, my lord. I am a candidate contesting in the election. Kindly see the FIR, my lord, at page 10. Our FIR is also at page 20 of the additional affidavit. I, Tariq Aman Mazumdar, presiding officer of so-and-so, do hereby lodge this FIR regarding a serious incident that occurred on 9th of April at around 9:40 AM at the aforementioned polling station. At the same time, Kartik Sonas Sinha, as the petitioner, the candidate of the Indian National Congress, along with his associate, unlawfully assembled and committed the following acts. Criminally trespassed into polling station without authorization, just, my lord, what I've picked up from the statute itself. Assaulted and used criminal force against police personnel to deter them from performing their official duties. Damaged and vandalized public property, including furniture, and created havoc among polling personnel as well as voters present in the queue. Well, these are the language which have been bodily picked up from the statute, and Lordship is aware of the Supreme Court judgment where Supreme Court says one should be very circumspect when such an affairs are lodged. These are all the handiwork of maybe some lawyer. Further, it is to mention that control unit of EVM machine was partially damaged, but ballot unit VVPAT were found intact with address tag and other seal. Well, my only humble submission is I am a candidate. On 4th, I have to arrange for so many things, my lord. And therefore, my lord, I should be allowed to remain on bail, my lord. And kindly come to page 20, the affidavit, the complaint which we filed, my lord, before the police, which has not been registered till date, page 20. At the instance of the ruling party, my lord, this polling officer has lost this FIR. Kindly come to page 20. I, Pankaj Nag, General Secretary, Karimganj District Committee, hereby lodge this FIR regarding a serious incident that occurred on 9th of April during the ongoing election at polling station number so and so. On this said, the authorized polling agent of the Indian National Congress, Amores Malakar, son of late Sunil Malakar, objected to certain individual attempting to cast false fake votes. Immediately thereafter, he was brutally attacked and physically assaulted by a group of miscreants. As a result of the assault, he sustained serious injuries and is currently undergoing medical treatment. Further, when Suraj Sharma, son of Ramkrishna Sharma, tried to rescue him, he was also attacked and seriously injured. Additionally, Sunil Sinha, son of late Dwarika Sinha, was also grievously assaulted in the same incident. The entire incident is reported captured in CCTV footage installed at the polling station. The accused person involved in this violent attack have been identified as Pinku Malakar, Osim Das, Sandeep Dotto, Sanjay Sinha, Virendra Soroy, and others. The accused person carried out life-threatening assault on the victim and also disrupted the peaceful conduct of election by engaging in illegal voting practice and obstructing official polling duties. The incident amounts to serious offences including physical assault, etc., etc. Therefore, I humbly request you to kindly register an FIR. Well, on this FIR, no action has been taken. But in the FIR filed by the polling officer, my lord, then, my lord, on the next page, my lord, page 23, this was the complaint which we lodged before the Chief Election Commissioner. This has also not been, my lord, acted upon.
And this FIR was communicated in WhatsApp. The WhatsApp screenshot is at page number.
And my lord, and page 21, it was also, a screenshot was also forwarded to the officer in charge of, my lord, Basarisara police station on his mobile phone. Nothing has been done. And on the contrary, my lord, because of this FIR, now the whole idea is either I do not remain in the polling counting day, or, my lord, I should surrender. So in this view of the matter, my humble submission is, my lord, pending consideration of the further consideration and, my lord,
below 7 years.
and, my lord, kindly see, these are all below 7 years. Only one voluntarily causing grievous hurt is only 5 years. And, my lord, one assault is 3 years, non-bailable. Others are all bailable. Therefore, my humble submission is, my lord, some protection should be given to the petitioner, especially considering the fact that 4th is the day when, my lord, he has to be present. He has to make a lot of arrangements as a candidate.
What happens during counting nowadays with the advent of EVMs? No physical papers are to
No,
be
my lord.
counted.
Lordship knows lot many things happens. One has to be very alert, my lord. Lordship, what is most important on a counting day is the later part. My lord, there are so many cases where a losing candidate has been declared by returning candidate as a winning, as if he has won. You fight an election petition, 5 years you contest. What happened in Uttar Pradesh, what happened in Bihar, everybody knows, my lord.
We don't know.
No, my lord, these are reality, my lord. My lord, I know one instance in Assam, my lord. It's a very old instance where a person owned by a very slender margin. Now, he was at that point of time, he contested on a new regional party's ticket. Then the civil subdivisional officer was purporting to help the ruling regime's candidate, though he lost. Then at the instance of a young IPS officer, my lord, the returning officer did not, that SDO, he did not, my lord, dare to do that. And I know both that IPS officer and the candidate, they are very good friends. The winning margin was only 280 votes. So this happens, my lord.
Had there been any truth in this FIR, they would have requested for recounting.
Yes, PP.
There is nothing on record to disbelieve the FIR also. It has been lodged by the presiding officer. And it has happened, Lordship, they have flatly refused that no such incident happened. And that will be evident from the case day, Lordship, whether such incident happened or not. And if the incident is taken as a whole, Lordship, it's a very serious issue, Lordship. Disruption in the process, Lordship.
But even then, you can wait to arrest him for 4, 5 days.
Yes.
It is not as if he has murdered somebody or
Yes.
like that. Especially because of this election thing.
Only thing, that's why I have come yesterday matter was mentioned, my lord, only for that, my lord. Watson can limit the days, number of days, my lord. Say for a week. No, yeah, only present.
This case day will come clean.
Case there is already fixed on 5th, if I'm not wrong.
Okay, then till 5th,
Yes.
since CD is fixed already. Hard learned is the Ken Chaudhary learned senior counsel. Assisted by.
Let it be ASI, yeah. Let it be ASI.
And learned additional PP. This is an application praying for so and so. Is submitted by Mr. Chaudhary that the petitioner is what are you, the office bearer?
No, I am the candidate.
Candidate is
Yes.
the candidate for the, which
LAC, this is.
Patharkandi LAC, my lord.
125 Patharkandi.
125 Patharkandi LAC.
LSC for the Indian National Congress Party in the recently concluded assembly elections, and the date of counting has been fixed on 4th of May 2026, and being the candidate himself, his presence is very much necessary at the time of counting of votes. And therefore
Candidate.
seeks interim protection. Para. Having regard to the nature of the allegations and in view of the aforesaid submissions, I am of the view that the petitioner needs to be protected as an interim measure till receipt of the CD. Accordingly, it is provided that the petitioner so and so shall be released on interim bail of rupees 50,000 with a surety for like amount to the satisfaction of the arresting authority in the event of his arrest in connection with the aforesaid case. Full stop. List again on 5 for CD.
My lord, can I make one request, my lord? Sir, tomorrow is a holiday, then again holiday. So my learned friend will communicate to the OC, my lord,
Yes.
regarding this
As
order.
you know, unless you get the CD, it will anyway get extended.
Yes.
See, in your
No, but
interest.
regarding the certified copy,
Yes.
I think my learned friend will communicate because because today it's already late, my lord.
I will also have to have the copy of the order also.
No, but you have hardly. You have hardly.
Furnish in view of the ensuing holidays on the next 3 days. Furnish a copy of this order to the learned additional PP, Mr. Thomas, so as to enable him to communicate the order to the concerned police authorities.
Deeply obliged.
Order item 38.
May I please your lordship?
Yes.
We have taken steps on 25/2/2026. Notice has been served to respondent number 2 to the officer in charge of the concerned police station. The same has been received by the Office of Learned PP.
report? PP? This is a matter of 2015 now. Can we wait for this?
25.
25-2, no? Five years, no?
Hmm?
5 years.
Yes, you had received the PP office has received it.
For the accommodation, within next week, any date, I'll.
Great. Learned additional PP submits that report as sought for has not yet been received and seeks further time. Release the matter again on
Next week.
7th. Yes.
39.
Run appears list again on 4x episode.
65. Forty-one, item number. Carried.
It's already past 4. I don't think we have time to.
They are directed to file an affidavit, they are willingness to pay 6 lakh rupees. What am I?
Willingness to pay?
6 lakh rupees, as they have promised, had order dated 24/2/2026, Lordship order. By Lordship, by Justice Anjanmani Kontya Lordship. 24/2/2026.
Yes, where's the affidavit?
Has been filed, but they have taken a stand that they need 12-month time at 50,000 per month. They have assured before this honorable court that they would clear by 6 months. Now, after 2 months, they have again sought for time, another 12-month lordship. Conviction was of 2014, appeal was order 2015 lordship. Now at the end, mid of 2026.
Lordship.
And their own conviction before this court has not been complied in form of affidavit in opposition. How can this lordship respondent complainant would believe in their assurance?
My lord, affidavit probably has not been reached by this with the record.
You are here, you can submit.
No, I submit. My lord, though the petitioner has sought for 12 months, at the discretion of the honorable court, it may be restricted to 6 months. And the entire amount to be paid within a period of 6 months by end of October. That order may be passed by the honorable court.
In the earlier order also, this 6 months is mentioned.
6 months, yes, my lord.
But in affidavit,
They
they have sought for 12 months from today.
All right, heard Mr. So-and-so. You're Mr. Alam.
Alam.
Alam Learned Counsel submits that Pursuant to order dated 24/2/2026, he has filed an affidavit which is not available on record. Full stop. However, learned counsel for the petitioner submits that in the said affidavit, a copy of which has been received by him, the petitioner has sought 12 months' time to clear the amount of rupees 6 lakhs at the rate of rupees 50,000 per month. Full stop. Mr. Alam, learned counsel, submits that this court may pass an order directing the petitioner to deposit the entire amount within a period of 6 months from today. To which the respondent number 2, counsel for respondent number 2 has no objection. Full stop. Accordingly, it is directed that the petitioner shall pay the entire amount of rupees 6 lakhs within a period of 6 months from today, either in lump sum or in installments. Full stop. So release the matter again after 6 months?
Pay the first amount within the 1 month, Lordship.
Out of which the
No
first,
installment, my lord.
Hmm?
Lordship has passed the order correctly. Because this petitioner is telling that it may not be possible to pay it by installment. So within 6 months, he will pay the entire amount anyhow.
What is the problem for furnishing in installment? I am agreeable. The first installment may within a 1 month, Lordship. Because his ten is changing, Lordship. That's why I am paying, Lordship.
if you can pay in lump sum, why can't you pay in installment?
Because probably he will arrange somehow, some property he may be required to sell because some amount he was to get from subcontractual works. He is not expecting it so soon. So some arrangement he will pay. Within 6 months, he has taken the time 6 months. Because he is telling that if installment is allowed, he may not be able to honor the this
You
order of the-
yourself in your affidavit
Yes,
said
yes,
he will pay by installment of 50,000 each.
15,000, 50,000 he can. 15.
Why not 1 lakh rupees in first month?
Because if it is within 6 months, then he has to pay 1 lakh.
Yes. No, we are not saying equal installments. Some installment you pay 50,000 within 1 month.
50,000.
Why you are arguing without the record?
It is further directed that the petitioner shall deposit an amount of rupees 50,000 out of the pending amount of rupees 6 lakhs within a period of 1 month from today. List the matter again on.
May I pay? May I pay for 1 lakh and before the registry?
Hmm?
Before the 1 lakh, 50.
Let us go with 50,000 first.
Before the registry, Lordship may direct to pay before the registry.
All right, before the registry. Don't work directly.
44.
May I please your lordship? Lordship, my senior is left the court, lordship, for some personal difficulties. Matter may be taken after 3 weeks.
Matter stands adjourned on ground of personal difficulty of learned counsel for the petitioner. List again on.
After 3 weeks, lordship.
Lordship, first week of May, Lordship, any date list. Because we're suffering from
5th of May. 9th is
Lordship, after 2 weeks.
9 to holiday Saturdays. 5th, 5th or 7th. Give.
45.
Please, your Lordship. Lordship, matter may pass over for the day as my senior is not present, Lordship, due to some health issues. Lordship, interim may be continued.
On prayer of learned counsel for the petitioner, list the matter again on so and so, none appears for respondent number 2. Interim order passed earlier shall continue till the next date of listing.